Good morning, sir. May I start, sir? Yes. Mic on.
Yes, Sujit.
May I start, sir?
Sujit, am I audible, visible?
May I start, sir?
Yeah, can you hear me?
Yes, it's audible, sir.
Okay. Yeah.
Honorable Dr. Justice A.K. Jayasekara Nambiar, Honorable Mr. Justice R. Narayana Pishareddy, Mr. T.S. Ajit, the other directors of the Academy, other members of the learned members of the Bar Council of Kerala, learned advocates. Good morning, everyone who are standing here. So, we all know that from 1st July 2024 onwards, we have got three new criminal statute in place by replacing the old criminal major acts. Some substantial changes are introduced in certain procedure areas through these enactments. So, therefore, to render the justice to all the stakeholders, it's our utmost duty that we have to stay abreast with all those changes thus introduced in the statute. So, one particular thing we shall bear in our mind that the changes thus introduced shall not be an headache to us first, and thereafter we can interpret it in a way that is suit to render justice to all citizens of the country. This law, now enacted, has come into force, and therefore there is no escape route before us. We have to get along with the same, and that is why the Judicial Academy also, alongside certain other institutions, has started a major exercise to give training to these three statutes to all the stakeholders. We have started giving training to the judicial officers. We have covered training to the prosecutors. We have covered training to the legal aid defense counsels, and we had given training to the staff members of the judiciary also. The rest is the advocates. The Honorable Chief Justice of India has directed all state judicial academies to give necessary training to the advocates also. So, from today onwards, we, in collaboration with the Bar Council of Kerala, we are starting a fresh journey. that we are not keeping the advocates in the framework of training of the Judicial Academy. We are taking you along with the other training to the other stakeholders in the academy itself. And this is the beginning of a new journey. As this is an idea which is mooted by our Honorable President, Dr. Justice Jayasankaran Nambiar, and we have started this exercise last year itself, that we have conducted a joint visual workshop whereby the representatives from the side of the lawyers were also taken in that process. So we are proceeding with that, and I am sure that this training is indispensable to the benefit of the lawyer community of the state of Kerala. I appreciate the Bar Council for taking initiative to conduct a training of this nature. And this morning, the Bar Council President and other members have mooted an idea that we can go to the district headquarters to give training to the advocates that those are practicing in those district centers and other mafusils also. So that is a very welcome suggestion. I will put it before the Honorable Board of Governors for their consent. And that said in introduction, I, as the director of the academy, with extreme reverence, welcome our Honorable President, Dr. Justice A.K. Jayasankaran Nambiar, the judge of Honorable High Court of Kerala, who is present virtually to this function. The President of the Bar Council of Kerala, Sri T.S. Sajid, he is also present, and he had shown extreme enthusiasm to conduct a training of this nature along with the academy, in collaboration with the academy. And on behalf of all of you, I welcome Mr. T.S. Ajit also to this function. The Director, Honorable Justice R. Narayana Pisharedi, he is the resource person, very academic resource person, very erudite judge of our former judge of our High Court of Kerala. He is the resource person who will enlighten us regarding the changes introduced in BNSS. With all humility, I welcome Honorable Mr. Justice Narayana Pisharedi to the function. My co-directors are also present here. I welcome them also to this function. And you on accepting our invite, turned on to the academy and to sit for this training. I know that as lawyers, it may be you may feel a bit difficult to sit for the next 2 days with that much of discipline that academy warrants. But I, on behalf of this academy, wholeheartedly welcome all of you to this function. And the other staff members and other the members who have rendered all help to the academy to undertake this training are also welcome to these functions. Sir, that said, it's your turn. I humbly request Honorable Justice Dr. A.K. Jayasankaran Nambiar to take over the floor from me.
Good morning to all, especially the director of the academy, Sujit, and the other directors, Justice Pisharedi, who's kindly consented to be the resource person today, members of the president and members of the Bar Council who are here today, and generally welcome to all the participants in this program. I would have said welcome to all of you and a warm welcome, but today being a very wet Wednesday morning, I don't think a warm welcome is in order. But I wanted to just impress upon you that this is a program that we are conducting based on the or giving or implementing the initiatives that were set in motion by the Chief Justice of India, who took this initiative to try and build the capacity of all the stakeholders with regard to the new criminal law regime that is to come that has already come into force from 1st of July 2024. The training program that we are organizing here is basically to equip the various stakeholders with the knowledge required to proceed in the criminal justice system after July 1st, 2024. The stakeholders, of course, you all know, are the judicial officers, the prosecutors, the lawyers, all of you, the court staff, which is important, the members of the criminal defense, criminal legal aid defense council, the district prosecutors, etc. Now, it is a Herculean task to be conducting training programs for all these stakeholders, but a feather in the cap for the director, Sujit, and other directors in the academy. We managed to do that in the short time that was available to us. The transition to this new regime, I want to first of all tell all of you, because I heard Sujit use the words escape from this regime. It is not so frightening that you need to escape. The laws, the new laws are substantially the same as the existing laws. There are minor changes, both substantive and procedural, but nothing that is going to be completely alien to people who have already been used to the existing regime. So let me, allay your fears, as it were, with regard to the new criminal laws. Apart from the change in the names of the legislations, I don't think there's much to be worried about, because it may get some time for you to be switching over from the familiar IPC, CRPC language or the lingo to the new BNS, BNSS, and the Sakshi Adhiniyam kind of titles. But that's nothing that you can't overcome maybe within a week or two. Now, as far as the academy is concerned, we've already conducted these transition programs for the judicial officers in our state, the district prosecutors, and also the Chief Legal Aid Defense Council. Very shortly, we'll be giving the training program for the APPs in the state also. Most importantly, we've also completed the training with regard to the court staff in the various courts in the state. And I say that is important because when you file your cases and when you have to comply with the procedure in the various courts, the court staff is the first person that you will encounter in the process of filing cases. So it's important, we thought, that they're also kept up to speed with the new regime. The training, as I said earlier, aims to equip the participants with a nuanced understanding of the various laws. And as I said earlier, there are not many changes, but whatever changes have come in are both important substantially and procedurally. So you need to spend a little time to try and understand, and you need not worry on that count also, because you've got one of the best resource persons you can have. Justice Pisharidi comes with a lot of experience. He is, I think he's probably the only one of us who's gone through the entire range of judicial, in the judicial hierarchy till the time he retired as a High Court judge. So he knows what affects the system at various stages in the progress from the magistrates court to the High Court. So I couldn't think of a better person. In fact, he's been the resource person for all the stakeholders, and including recently in the High Court as well. So I think it will be a seamless exercise as far as all of you are concerned when it comes to knowledge sharing and knowledge accumulation. Just a word about what we're doing at the Judicial Academy itself. Last year, we brought about a paradigm shift in our training methodology. As you all know, normally the Judicial Academies used to have, conduct lectures for the judicial officers. But last year, we brought about a paradigm shift in the methodology that we are adopting in the Judicial Academy. And we changed over from what was earlier a pedagogical style to what is now called the andragogical style. For beginners, pedagogy basically means child-led learning. So it is education methodology which is more suited for schools and colleges. But when it comes to adult learning, which is what we are doing here, it's a completely different methodology that operates. And worldwide, adult teaching methodologies are different from what you would normally find in a school or a classroom. So we have shifted over to that kind of methodology. And I must say, to the credit of the academy and to my own personal satisfaction, that the results have been very, very encouraging. And the response of the judicial officers has been even more encouraging. The judicial officers have actually started believing in a particular purpose of coming to the Judicial Academy. They are actually willing to come to the academy, and and I would dare say that they yearn now to come to the academy. So, if that is the response that we have, then as a judicial learning institution, we would like to share our experiences with the rest of the stakeholders in the judicial community. It's not that we don't want to impart or give our training to the other stakeholders. Unfortunately, we have our own limitations of infrastructure, space, and that's why we've not been able to actually. We're trying our best to extend this facility to almost all the stakeholders in the legal profession in the state. But as I said, the infrastructural limitations do play a significant part in disabling us from doing that. But at the same time, thanks to the efforts taken by the Bar Council, we actually have been able to hold this particular program in hybrid mode. Technology that way has helped us, in our outreach. And kudos and congratulations to the Bar Council for this initiative and enabling us to have this knowledge sharing exercise across the state to various to the lawyer community in general. And I think that's important because we all know that as lawyers we are perpetually law students, including when we become a judge. You have to always have that humility inside you, and that is the first ingredient for successful learning. If you go out to the court, if you sit in your class in these lecture halls, if you go for a case with the thinking that you already know something, then you're basically going on a wasted exercise, because judicial learning is a continuous exercise, and you never actually we get swayed by all these titles that we get. We are called the Bachelor of Laws, we're the Master of Laws, and we're the Doctor of Laws. To tell you the truth, we are not any of these. You never become a Bachelor of Law when you start practicing as a lawyer, because there is this rhetoric that law is a jealous mistress. So you're married to the law. You never become a Bachelor of Law. You're never a Master of Law. You're always a student of law, and you're never a Doctor of Laws. You always have to be patient, right? So the methodology that we use in the Judicial Academy is trained to that. It is basically designed to make people think that they don't know everything, and there is always something new to learn. And this is what we want to try and establish. I once again congratulate the Bar Council of India and the Bar Council of Kerala for having taken this initiative, for enabling the academy to spread its tentacles to the various stakeholders. And I also wish this function all the best. Thank you.
I request Sri T.S. Ajit to render his felicitation remark.
Good morning to all. Most respected Honorable Mr. Justice A.K. Jayashankar Nambia, Honorable Mr. Justice R. Narayana Pishali, former Judge, High Court of Kerala, Sri Sujit K.N., the esteemed Director of the Kerala Judicial Academy, Sri K. Krishnakumar, Additional Director of the Kerala Judicial Academy, my colleagues, Bar Council member, Sri P. Santosh Kumar, Sri Mohitin, Sri Devi Kumar, Sri Sudarshana, and diverse advocates who are guiding us with their presence from various bars across the camp. It is with profound respect and a deep sense of privilege that we gather here today to acquaint ourselves with the three newly elected laws. These laws, though subtle in their modification, promise to yield a transformative impact on our criminal justice delivery system. This distinguished course, meticulously organized by the Kerala Judicial Academy, at our earnest request, signifies an unprecedented and monumental step forward. The Bar Council stands in deep gratitude for the benevolence and magnanimity demonstrated by the Board of Governors of the Kerala Judicial Academy. In a gesture of reciprocal commitment, the Kerala Bar Council has resolved to orchestrate comprehensive training program across every district within the state of Kerala. We earnestly beseech the Kerala Judicial Academy to extend their esteemed faculty members, ensuring the triumphant and seamless implementation of these courses throughout the state. Our heartfelt appreciation is boundless for the Kerala Judicial Academy's steadfast support towards the legal fraternity. We extend our special thanks to the Honorable President of the Board of Governors, Honorable Mr. Justice A.K. Jayashankar Dambia, and the esteemed Director of the Academy, Sri Sujit Kayan. Your unwavering dedication has been a beacon of inspiration, and we are ardently look forward to future collaborations that will undoubtedly enrich our collective mission. With deep gratitude and sincere appreciation, we thank you all once again. Thank you.
That's the end of our brief inaugural ceremony. So, His Lordship, we may start, Your Lordship, our official classes. The permission of Your Lordship, you know
Thank you.
that now you have come to the academy, and this training we have stitched in such a mode that there shall be proactive engagement from your side, so that we should have a mutual sharing of ideas, and thus taking this training session to the level of mutual satisfaction, and it is worth enough at the end. So my request to all of the participants is that there shall be mutual sharing of ideas. You may have your own line of thinking about a particular legal provisions introduced in the statute that is to be shared with us, so that none of you will be blamed for any kind of suggestion put forth before us. As His Lordship said, we have turned to the method of andragogy. Andragogy method, you all know that only if you feel it is beneficial to you, you will listen something that will come across in front of you. So this kind of training will enable us to reach ultimately after the training that there shall be a consensus regarding the way forward. Otherwise, the system will be the sufferer, and we shall not leave the system to suffer even in a very minute way. So I request all of the participants to be proactive and engage yourself throughout this training process. I know that sitting for a training for continuously for 2 days is a difficult task, but despite that, we have to do that because the situation actually demands that from us. So, with all humility at my command, I request Honorable Mr. Justice R. Narayana Pisharedi to take over the floor and eyes from me and commence the session straight away.
Good morning to everyone present here. The three new criminal statutes have come into force on 1/7/2024. Out of them, The Bharatiya Nagarik Suraksha Sanhita, for short the BNSS, contains some drastic changes which have got some impact with the procedural formalities. And for a very long time to come, the judicial officers, the public prosecutors, the lawyers, the police officers, all stakeholders have to deal with the CRPC as well as DNSS. Can anybody say the reason? We can have a mutual interaction, no problem. And you will have to set your inhibitions, especially the younger participants. Which a provision can you say? Yes, sir. It's section 531 of the BNSS. That is the last section. I will straight away invite your attention to section 531. Section 531 says the Code of Criminal Procedure 1973 is hereby repealed. Well and good. Then comes subsection 2, section 531(2). Notwithstanding such a repeal, then comes the problems. In spite of such a repeal, if immediately before the date on which this Sanhita comes into force, there is any appeal, application, trial, inquiry or investigation pending, then such appeal, application, trial, inquiry or investigation shall be disposed of, continued, held or made as the case may be in accordance with the provisions of the CRPC. So whatever matter pending before the court or the investigating officer shall be continued. Pending as on 1/7/2024 shall be continued in accordance with the procedure under the CRPC. And the new matters will be covered by the BNSS. Simply said, that is the effect of clause A of subsection 2 of section 531 of the BNSS. Now, merely by stating this, it may appear to be a very simple thing, no problem. But when we go to the practical side, these problems may arise. I will refer to the recent 3 decisions which have come on BNSS. That will make you understand the problems. The first decision was rendered by the Punjab and Haryana High Court on 2/7/2024. Suppose a complaint for an offence punishable under section 138 of the NI Act is filed before the date 1/7/2024 with an application for condonation of delay. It was barred by limitation at that time, but an application for condonation of delay is also there. The application for condonation of delay was allowed by the court after 1/7/2024. After 1/7/2024. So technically speaking, the complaint for the offence will come into existence before the court only after 1/7/2024. Right? Technically. But the Punjab and Haryana High Court held that in principle, because before the High Court it was a revision application. Once the application for condonation of delay is allowed to let back, and the complaint for the offence under section 138 will be deemed to have filed within the period of limitation before the date 1/7/2024, and it shall be dealt with in accordance with the provisions of the CRPC and not under the BMS. I hope you have understood. These types of problems may arise. Next game. Now, next game on 9/7/2024, the decision of the Rajasthan High Court. The question before the High Court was whether an application for quashing a proceedings, whether it should be filed under section 482 of the CRPC or under section 529 of the BNSS. The matter before the lower court was pending before 1/7. It was a matter pending before the lower court already. An application for quashing that proceedings, whether it should be filed under section 482 CRPC after 1/7 or under section 5. Sorry, 528, 529, 528 or 528 of the BNSS. And the Rajasthan High Court held relating to the crime in that case was registered before 1/7/2024 in February 2024. The Rajasthan High Court held everything arising out of that crime, investigation, inquiry, trial, everything will be covered by the CRPC because the crime was registered before 1/7/2024. However, that cannot be taken as a final opinion because it is only a view of one of the high courts. There are other views taken by other high courts. On 11/7/2024, the Punjab and Haryana High Court again rendered a decision. In that case, an application for quashing was filed under section 482 CRPC for quashing an FIR. The High Court considered the matter whether the application after 1/7/2024 should be filed under section 482 or section 528 of the BNSS. Finally, after considering a category of decisions, the Punjab and Haryana High Court held every application filed on or after 1/7/2024 shall be filed under the provisions of the BNSS. That is a contrary view. Whatever be the application filed after 1/7/2024, it should be filed under the BNSS. That is view taken by Punjab and Haryana High Court. Whether the matter is pending, whether the matter is new, irrespective of that. But that is I think, an extreme view. And not only that, the High Court also held that on that score alone, only because this application is filed under Section 482 of the RBC, it is liable to be dismissed. And the High Court dismissed the application, granting liberty to the petitioner to file proper application under the provisions of the BNSS. The High Court could have very well treated this as an application under Section 482 of the RBC if it was of that view. But it is held that merely because the provision quoted is wrong, the application is liable to be dismissed. I think that is an extreme view, and it goes against the Supreme Court rulings, because misquoting of a provision will not render an application liable to be dismissed. The court can, what is to be considered is the source of power of the court, whether it can do the court or not. That is to be considered. Huh? That is a saving clause. Saving clause is that. That is why it is saving clause.
Till then, what his lordship says is that the act is enacted with a saving clause.
Saving clause in there.
Because of this saving.
If that saving clause was not there, what you say is perfectly correct.
Citations are.
If you have got a live law subscription,
Yes.
all these three decisions are reported in live law.
If you want it, we have downloaded it and we will share with one among you so that it can be circulated among you.
All the three decisions. Now, as far as the revision applications and appeals are concerned, there may not be much problem, because there is no drastic change with regard to the procedure. Whether it is a provision under the BNSS or under the CRPC, the procedure is the same. No change at all. So that may not be much of problems, create problems. Now suppose an investigation, an FIR was registered before 1/7/2024 with respect to non-bailable offences. The investigation continued after 1/7/2024. Charge sheet could not be filed within the period of 60 or 90 days. Whether the application for default or the claim for default bail should be considered by the court under the provisions of the CRPC or under the BNSS. Of course, this will have only for a short time. That problem will arise. The Supreme Court had held that it is to be treated under the provisions of the CRPC. That is AIR 1975 Supreme Court 1465. AIR 1975 Supreme Court 1465. Now, doesn't anybody think of why a decision was rendered by the Supreme Court in 1975? As that is, the 1898 code was repealed and the Code of Criminal Procedure 1973 came into force with effect from 1/4/1974. Then also in the code, in the CRPC, there is a similar, more or less similar provision. That is section 484 CRPC. 484 CRPC. Interpreting the provisions of section 484 CRPC, the Supreme Court then held the default bail application has to be considered in accordance with the old code, then 1898 code then. That principle can be now adopted now also. Same principle, because the provision is more or less the same. There is no change with regard to the provision, with regard to the saving clause, with regard to the investigation. Now, suppose an act or offence is committed before 1/7/2024. And an offensive act, an offence committed before 1/7/2024. But the information regarding that offence was given only after 1/7/2024, and the FIR was registered only after 1/7/2024. Whether the investigation should be conducted in accordance with the provisions of the CRPC or the BNSS.
BNSS, CRPC.
As you stated,
CRPC.
different high courts have taken different views.
Because offences committed on before one.
Of course, IPC, with regard to the offence, the penal provisions will be the IPC, no doubt. Penal provisions will be, I am open the procedure. Procedure for investigation. Some high courts have taken the view that CRPC should apply, but some high courts have taken the view that it is the BNSS will apply in principle at that time, interpreting section 484.
Investigation.
For example, the Gujarat High Court has taken a view interpreting section 484 CRPC that if that principle is adopted here, if a proceeding is instituted subsequent to the commencement of the BNSS in respect of the act or omission committed before 17, before coming into force, that BNSS, it would only be governed by the provisions of the BNSS. That is the principle of the adopted by the Gujarat High Court. That is, you may get it 1976 Criminal Law Journal 84. 1976 Criminal Law Journal 84. In the KSC also. Corresponding citation you will get. Now, however, our High Court has taken a different, our High Court has taken the same view. Our High Court. The High Court has emphasized the fact that when you look into the language of clause A of subsection 2 of section 531, it is in present tense. Investigation pending, trial pending, inquiry pending. It is in the present tense. So what is to be looked into is when the new statute came into force, whether it is pending. If it is pending, it is covered by the provisions of the CRPC. Otherwise, it will not. You may refer to KLT 739. 1975 KLT 739. KLT 739. Though this ruling was, this decision was overruled subsequently, but that is on some other point, not with regard to this, not on this point. So the dictum laid on by the High Court on this point still survives. So these are some of the problems. Now we will look into, we will consider these problems as and when the other provisions are dealt with. Otherwise, whole day we will be on 531.
Sir, then on hearing this, what is your take on this? Or you may have worked out on this point that is pending.
I think as far as our High Court is concerned, no problem. Whether for example, in order to quash an FIR, whether 482 is shown or 528 is shown, no problem is there. I think. Any objection made by the registry? The High Court?
No.
I don't think so.
They have contacted us and they said so. And now that was taken by a bench also. Soon a decision will come on that point. What is to be the way in our state how this 531 will apply? That the division bench has taken note of these things and registry has given a note to the division bench. A decision will come soon. But as regards as of now, that as His Lordship said, there is a Kerala decision also, and the Supreme Court is also taken a view that we have to keep it in silos. Is pending means is pending as on that day.
One thing you will have to take care of is that, see, ഒരു FIR രജിസ്റ്റർ ചെയ്തിട്ട് അതിനുശേഷമുള്ള എല്ലാ പ്രൊസീഡിങ്സും പെൻഡിങ് ആയിരിക്കുന്നതല്ല പറയുന്നത് സേവിംഗ് ക്ലോസിൽ. അതിനുശേഷം വരുന്ന എല്ലാ പ്രൊസീഡിങ്സും പെൻഡിങ് ആണെന്നല്ല ഈ സേവിംഗ് ക്ലോസിൽ പറയുന്നത്. പിന്നെയോ ഈച്ച് സ്റ്റേജ് ഈസ് കമ്പാർട്ട്മെന്റലൈസ്. ഇൻവെസ്റ്റിഗേഷൻ, എൻക്വയറി, ട്രയൽ, അപ്പീൽ, ആപ്ലിക്കേഷൻ, എക്സെട്ര എക്സെട്ര.
That is to be taken note of. Each stage with a comma.
With pending as on 1/7/2024.
നിങ്ങൾക്ക് എന്തെങ്കിലും any other view you have?
Sir, one doubt. Sir, if a crime is occurred on or before 1/7/24, and the FIS is only come on 3 or 4 of this July, then if my understanding is correct, then the CRPC should be to follow, because the offences happen now before the commencement of this act. The clarity-
As I stated earlier, different high courts have taken different view in this matter.
At this time, how we can
But
sustain the
as far as our high court is concerned, this decision is there. 1975 KLP 739.
That process starts only after the act has come into force. Process starts. So though it's a substantive offences comes under IPC, the investigation procedure should be governed by the new Sanhedrin. Should be governed by BNSS.
But there are other views
Of
and possible views. Possible views. I don't say it is not possible. It is possible. But as far as our high court is taken, the decision interpreting for section 484 is still there. Though that decision was overruled on some other aspects.
All these are till an authoritative pronouncement comes. Thereafter, we will be guided by that pronouncement.
Revision application not out at all, because if a new revision application is filed, whenever the matter before the lower court was pending, if it is a new revision application after 1/7/2024, it is governed by the new statute. Supreme Court has made it very clear, that is AIR 1976, Supreme Court 1185. Supreme Court specifically considered the question of revision applications. AIR 1976, Supreme Court 1185. AIR 1976, Supreme Court 1185.
അതിൽ ഈ ആപ്ലിക്കേഷന്റെ കാര്യം അവിടെ പറയുന്നുണ്ടല്ലോ. ഈ ആപ്ലിക്കേഷൻ നിങ്ങൾ how you will interpret the term application that is embodied in 531(2)(a), that all application in a pending case is not that. It's an original application and has got an independent standing.
That is the recently, as I stated, the Punjab and Haryana High Court did not take that view. Every application should be under the BNSS after 1/7. That is view taken. Otherwise, the petition should be dismissed. That also said.
And this revision and cumulacy also, our High Court has numbered it under BNSS, and a decision has also come. That is under BNSS. That is rendered by Justice Badruddin a few days back.
അല്ല, അത് ഒരു പറഞ്ഞിട്ടുണ്ടെന്നുള്ളൂ.
പക്ഷേ ഇനീഷ്യലി രജിസ്ട്രിയിൽ
Consideration ഒന്നുമില്ല.
നോട്ട് ചെയ്ത് നമ്പർ
There is no consideration of the provisions. Now, one more thing, I am not discussing upon that. When you read section 531 CRPC, of the BNSS, you will have to also keep in mind section 6 of the General Clauses Act. Section 6 of the General Clauses Act. And in respect of acts committed before 1/7/2024, the saving clause in the BNS. Saving clause is also there in the BNS corresponding to IPC. Those provisions have also to be kept in mind. Section 6 of the General Clauses Act is very important. Now we will come back to the beginning portion. Before proceeding further, I must state that I will be dealing with only the important changes only, not the minor changes, because if we discuss each and every minor change, there may not be time. That is why. Now there are 5 new definitions in the BNSS. 5 new definitions. The first one is the first definition is section 2.1a. Section 2.1a of the BNSS. Audio, video, electronic beams. Audio, video, electronic means shall include use of any communication device for the purposes of video conferencing, recording of process of identification, search and seizure or evidence, transmission of electronic communication, and for such other purposes and by such other means as a state government may by rules provide. So apart from this, other things can be notified by the state government. Rules can be provided by the state government. Now, the second new definition is with regard to bail. As you are aware, bail is not defined under the CRPC. Now it is defined. Section 2B. Section 2B states 2.1b. Bail means release of a person accused of or suspected of commission of an offence from the custody of law upon certain conditions imposed by an officer or court on execution by such person of a bond or a bail bond. This is in consonance with the definition of bail given by in the decisions of the Supreme Court. More or less. As you know, in one case the Supreme Court has held that bail actually means release of a person from the custody of law or the custody of police and entrusting him with his own persons who are the sureties. That is actually bail. Now, section 2.1d, bail bond. Bail bond means an undertaking for release with surety. Now, section 2.1e, bond. Bond means a personal bond or an undertaking for release without surety. So, simply stated, in bail bonds, there is always a surety. It is releasing a person on execution of bond with the sureties. But in the case of bond, there is no surety. A mere undertaking by an accused may be sufficient. That may amount to a bond under the definition. See, bond means a personal bond. That means a bond executed by the accused himself without any surety. Then, or an undertaking for release without surety. A mere undertaking. That will be sufficient. Now, the other new definition is under section 2.1i. Electronic communication. Electronic communication means the communication of any written, verbal, pictorial information or video content transmitted or transferred, whether from one person to another, or from one device to another, or from a person to a device, or from a device to a person, by means of an electronic device, including, that is very important, including a telephone, mobile phone, or other wireless telecommunication device, or a computer, or audio video player, or camera, or any other electronic device or electronic form as may be specified by notification by the central government. So any other device can be notified as means of electronic communication by the central government under section 219. So these are the 5 new definitions. Audio video electronic means bail bond, electronic communication. Now, certain definitions have been deleted. The definition of India is deleted. India omitted in the DNSS. Then the definition of metropolitan area omitted. Metropolitan area omitted. From 1/7/2024, as per the provisions of the DNSS, there will not be any pleader. There will not be any pleader. Pleader omitted. Government pleaders will be there. That is under the CPC. Then the definition of prescribed omitted. The definition of prescribed omitted. Now there are modifications to 2 definitions. The first one is investigation. Investigation 2.1 L 2.1 L. The main provision is same as in the CRPC definition, main provision. But an explanation is added. The explanation says, where any of the provisions of a special act are inconsistent with the provisions of this Samhita, the provisions of the special act shall prevail.
State enactment may override the central enactment. To allay that fear, it is introduced.
Even otherwise, general principle is that when a special procedure is prescribed under any special statute for investigation, that will prevail over the general provisions. One of the jurists has said that this is added. Then why it is added here for investigation? It is added because in order to remove the apprehension that in some state acts there may be special procedure prescribed, even that will survive in spite of BNSS. Only to clarify that. But we may not be able to understand that meaning from merely reading this explanation.
There are enactments like MACOCA, Maharashtra Organized Crimes Act, and there is a special scheme of investigation is designed under that act. And when a central act comes, it may have certain impacts on pending procedures in the proceedings commenced under those enactment. To clear the air, this explanation is added in CRPC. That is a view expressed by that eminent jurist.
Now, the definition of victim is given under section 2WA of the CRPC. Definition of victim. Now, I will give you an example. Suppose a vehicle hits on a person in a motor vehicle's accident and causes that person injury. That vehicle did not stop, but a case was registered. Ultimately, because the identity of that driver could not be ascertained, a refer report was filed. Nobody was charge sheeted. Under section 2WA, the victim is of the CRPC, victim is defined. Whether under that definition, this injured person can be considered as a victim. Can he be considered as a victim?
Under CRPC.
Under CRPC, 2WA. Yes, that is
Precisely that.
nobody is charge sheeted, so he will not be a victim under the definition. Now this drawback is removed under the definition of victim under the BNSS, that is section 21Y. 21Y. 21Y says victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person that who has been charged, that is omitted, and includes the guardian or legal heir of such victim. And if you want to understand more with regard to this slight difference, you may read a decision of the Kerala High Court, 2021, 1 KSC 111. 2021, 1 KSC 111. Suppose this is not with regard to a change. Suppose a person has died in an accident. Suppose in the earlier example that person died. In order to come under the definition of victim, whether under the CRPC or under the BNS, is it necessary that a legal heir, whether he should be a person eligible to inherit the property? You know, all legal heirs may not be eligible to inherit the property under the civil law. So, is it necessary that he should be a person, legal heir, he should be a person, whether is it necessary that he should be a person eligible to inherit the property under the personal law or under the statute? our High Court has held that it is not necessary. It is not necessary. That is 2018 1 KSC 488. 2018 1 KSC 488. Now, under section 2Y of the CRPC, suppose if a word or expression is not defined in the CRPC but defined under the IPC, that definition under the IPC could be adopted for the purpose of CRPC. That is section 2Y of the CRPC. Now that provision is reintroduced as subsection 2 of section 2.2 with an addition. It says words and expressions used herein and not defined but defined in the Information Technology Act, that is added. Defined in the Information Technology Act 2000 and the BNS shall have the meanings respectively assigned to them in that Act and Sanhita. So, whatever definition, if it is not under the BNS, whatever definition given under the IT Act, that can also be adopted. Apart from the definition in the BNS that is corresponding to IPC.
That is important also. Take note that some of the definitions in the IT Act has got some relevance when we interpret some of the provisions of these BNSs. So especially in that 2.1a, that communication device, no definition attached to BNSs, but it has got a definite definition in IT Act. In that way, subsequently also it has got some sort of relevance.
Now, from 1/7/2024 onwards, there is no metropolitan magistrate or chief metropolitan magistrate in our country. Under section 6 of the BNSS, that is classes of criminal courts, this category, metropolitan magistrates, that is omitted. That is omitted. Section 6, that is not there. Though we are not concerned in our state, there are no metropolitan magistrates. Now, from 1/7/2024 onwards, there is no assistant session judge. There is no assistant session judge. Section 8 of the BNSS, Court of Session. Court of Session. Corresponding provision was section 9 of the CRPC. Section 9(3) CRPC provided the High Court may also appoint additional session judges and assistant session judges to exercise jurisdiction in a court of session. Now, section 8(3) corresponding provision says the High Court may also appoint additional session judges to exercise jurisdiction in a court of session. No assistant session judge. അപ്പോൾ ഇന്നലെ നിങ്ങൾ കോടതി പോയപ്പോൾ അവിടെ അദ്ദേഹം ഇരിപ്പുണ്ടായിരുന്നില്ല അസിസ്റ്റന്റ് സെഷൻ വൈ
എന്തുകൊണ്ടാണ് അദ്ദേഹം ഇന്നലെ സിറ്റിംഗ് നടത്തിയത്? യെസ്.
Shall not object that no such courts and you cease to
Hey,
be an additional.
you are not an assistant session judge. Now, from here onwards, everywhere in the BNSS, in every profession in the BNSS, where CRPC had provided the anything with regard to assistant session judge, that has been omitted subsequently in everywhere with regard to appeals also. Now, section 8 to 7, 8 to 7. It says the sessions judges may from time to time make orders consistent with the Sanhita as to the distribution of business among such additional session judges. That means new cases cannot be made over to the assistant session judge. Then such changes are there in the corresponding subsequent provisions in the BNS. Now there is slight changes I am omitting, with which we are not concerned. Now, section 20 of the BNSS. We are not much concerned with that provision. That is a directorate of prosecution. Directorate of prosecution. There are some changes. Corresponding provision was section 25A of the code, capital letter A. Now it provides for the establishment of a district directorate of prosecution in every district. Subsections 1 to 12 are there. The provision deals with the functions and obligations of Deputy Director of Prosecution, Assistant Director of Prosecution, Director of Prosecution, etc. All these things. Now, section 27 of the CRPC dealt with jurisdiction in the case of juveniles, cases with regard to juveniles. Section 27 CRPC. That is omitted. No new provision with regard to corresponding provision in the BNSS. Why? Judge Act. Then the sentencing powers of magistrates. That is section 23 of the BNSS. Section 23(1) of the BNSS deals with the powers of a chief judicial magistrate. There is no change. There is no change. It is the same as in the court. Section 23(2) of the BNSS deals with the powers of the court of a magistrate of the first class magistrate. There, what is the amount of fine which can be imposed by a first class magistrate under the code? Rupees 10,000. That is now enhanced to rupees 50,000 50. Then, regarding the second class magistrate, section 23(3), that fine is enhanced from rupees 5,000 to rupees 10,000. Though we are not concerned because there are no second class magistrates in our state. Then, as per subsections 2 and 3 of section 23, the first class magistrates and the second class magistrates are given power to impose a new form of punishment under the BNS. What is that? Community service. Community service. And what is community service? That is explained under the explanation to that provision, section 23. Community service shall mean the work which the court may order a convict to perform as a form of punishment. So it is a work, community service is a work which a court may order a convict after sentence, convict to perform as a form of punishment. Then that work should benefit the community. As a form of punishment that benefits the community. It should be some work that benefits the community. Then, for which he shall not be entitled to any remuneration. He will not be entitled to any remuneration. That is why it is called service. Service. So it is a work which a court order a convict to perform, and that work should benefit the society, some work which should benefit the society, and it is without any remuneration. That is a service. That is community service. Now, it's very simple, but there are problems because there are no parameters provided for imposition of this sentence. Suppose a magistrate finds that a person guilty, thinks that community service is the punishment to be imposed on him. For what time he will impose this punishment? 1 month, 2 months, 3 months, 6 months, 1 year, remainder of life? No time provided. So, wide discretion is given to the magistrates. That is one thing. Then we can take cue from some other provisions with regard to the limitations of a magistrate. For example, a judicial first class magistrate. What is the limit of his power to impose a sentence of imprisonment? 3 years. So at any rate, he cannot. We can reasonably assume that he cannot impose a punishment of community service for more than 3 years. Then, suppose a punishment of imprisonment is also provided for that particular offence for which he is convicted. Suppose it is punishable with 1 year. Suppose. Then we can say that, reasonably say that, the magistrate cannot impose a sentence of community service for more than 1 year, at least for that offence. These types of inferences should be made with regard to the limit. Then the other thing is there always. A sentence should always be reasonable. the general principle. It should be proportionate to the crime. So that, considering the nature of the offense, the term can also be fixed by the, should be a reasonable one. That's the general principle. Now, suppose a person refuses to do community service after ordering by the machine. He fails to do or he neglects to do. Huh? Under the BLS, section 8, it is stated that he can be sentenced to imprisonment in default of performance of community service. But there also there is a problem. Section 8(4) of the BNS states that the imprisonment which the court imposes in default of payment of a fine or in default of community service may be of any description to which the offender might have been sentenced for the offence. Fine. Then, section 8(5). 8(4) പിന്നെ 8(5). BNS corresponding to IPC. Then 8(5). If the offence is punishable with fine or community service, the imprisonment which the court imposes in default of payment of the fine or in default of community service shall be simple. Simple ആയിരിക്കണം. Fine and community service മാത്രം provide ചെയ്തിരുന്നതാണെങ്കിൽ it shall be simple. There is no problem. But then comes a problem. And the term for which the court directs the offender to be imprisoned in default of payment of fine or in default of community service shall not exceed. Then the scale is given only with regard to the fine. പറയുന്നത് എങ്ങനെയാണ് പറയുന്നത്? In default of payment of fine or in default of community service shall not exceed. Imprisonment ഈ സ്കെയില് ഇനി പറയുന്ന സ്കെയിലിൽ കൂടുതൽ പാടില്ല എന്ന് പറയുന്നു. എന്നിട്ട് പറഞ്ഞത് എന്താണ്? പറഞ്ഞത് ഫൈനിന്റെ കാര്യം മാത്രമേ പറയുന്നുള്ളൂ. പിന്നീട് 2 months when the amount of fine does not exceed 5,000 rupees, like that. So suppose a person is convicted and he is sentenced to do community service for a period of 3 months. He refuses or he neglects to do that. What should be the default sentence of imprisonment? That is the maximum limit. In any case, community service ആയിട്ട് എടുക്കേണ്ടി വരും. അപ്പോഴും മാക്സിമം ലിമിറ്റേ പറയുന്നുള്ളൂ. It shall not be more than 1 year. So that is a problem. Then there is another problem. Suppose he performs the community service, so he is sentenced to do community service for a period of 3 months. He performs the community service for a period of 1 month. Thereafter he says, no, it is not my job. I cannot do this. Okay. ഇത് എനിക്ക് പറഞ്ഞിട്ടുള്ള ജോലിയല്ല. Then for the remaining 2 months he should be given, he may be given default sentence. What should be that period? How we will calculate? That is a problem. Then these are the problems. These are the headaches of the magistrates. That is also there. I am coming to that.
What is your take? You have gone through this profession some way or other. You are familiar with this mode of punishment also. What is your take on that? Have you got any sort of suggestions to put?
Is there any similar provision under any other statute? Judge Act, Section 18, 18C.
എന്തെങ്കിലും ഉണ്ടോ? That in what way we can supervise this scale of default? One suggestion is that, pardon? Border?
That is why I am coming. We are coming to that.
That who shall be appointed?
Who shall supervise this work? Who shall monitor this work? Who shall evaluate this work?
That is there
Not
in
provided.
PO Act. PO Act and JJB, it's there.
See, the criminal law should always be precise and clear. Clarity, certainty. That is something lacking with regard to, at least with regard to this provision. It is a welcome provision, no doubt. It is a welcome provision. In foreign countries, it is already there.
And there is in UK, there is a practice also. We can adopt many good things from the practice at there, but we cannot match with their facility on this count. So, in rules, we have to introduce something to augur well with the amendment introduced in this BNSS. So, that is why I am seeking suggestions from your side. If you have got any suggestions regarding the implementation, we can take note of at the time of framing the rules. That is one thing. That is one thing in our optics. That Probation of Offenders Act, there is a scheme in Visas there.
And whether the superior officer there or whether the head of office there should be asked to give a certificate regarding the
There in certain Western countries, and also in India Act that motor vehicles officials are doing that. That also in our cognizance.
but more പ്രാവശ്യം എഴുതാൻ പറയാം 100 times എഴുതാൻ പറയുന്ന that is not a community service. Who is benefited? He himself benefits.
Yes. That
കമ്മ്യൂണിറ്റി സർവീസ് ചെയ്യുന്നിടത്ത് പോലീസുകാരുടെ ഒരു സൂപ്പർവിഷനിൽ അത് ചെയ്യാവുന്നതല്ലേ?
പോലീസുകാരെ ഏൽപ്പിക്കാൻ പറ്റും.
അല്ല, അത് ഒരു ഡ്യൂറിങ് ഒരു പർട്ടിക്കുലർ പീരീഡിലെ ഇപ്പൊ ഇത്ര മണി മുതൽ ഇത്ര മണി വരെ എന്നുള്ള ഇപ്പൊ റീസെന്റ് ആയിട്ട് തന്നെ ഒരു കേസിൽ ഹോസ്പിറ്റൽ സർവീസ് ഒരാൾക്ക് MPD പ്രൊവൈഡ് ചെയ്യും. ആ സമയത്ത് അവിടെ ഒരു ആ ഒരു ഡ്യൂറിങ് ആ അവേഴ്സിൽ പോലീസുകാരുണ്ടാകും.
May be that the person, when we are assigning a person to a particular institution, normally and generally the head of the institution is the person able to say what is the work to be done in that institution.
Court can give direction to that.
Yes. That is one option. That is also we are contemplating with that. Legal Service Authority, we can depute them. He alone knows what work to be done as regards that institution. And then there is somebody.
But then there will be raise a problem. The court will have to ascertain beforehand because he cannot say this work should be done. It is for the court to direct to do that
Consider
particular work.
that we have to take note of some other aspects also. The health of this person.
Some institutions can be recognized. That can be.
അല്ല വക്കീലത് അതിലാണ് പറഞ്ഞത് നമ്മൾ ഇവരുടെ പ്രൈവസി അബ്സല്യൂട്ട് ബ്രീച്ച് ഓഫ് പ്രൈവസിയിൽ ഇത് കൊടുക്കാൻ പറ്റില്ല. വി ഹാവ് ടു ടേക്ക് നോട്ട് ഓഫ് ഹിസ് ഹെൽത്ത്. ഒരു വളരെ ചെറിയ മനുഷ്യനോട് ഒരു വളരെ വലിയ പണി ചെയ്യാൻ പറയാൻ നമുക്ക് പറ്റില്ല.
You will have to consider the age, the health. He has got a skill in his special profession. All these things.
അത് ഇറ്റ്സ് യുവർ ഡ്യൂട്ടി ഓൾസോ. കൺഫർമേഷനിലാണല്ലോ ഇത് വരുന്നത്, അപ്പീലിലല്ലല്ലോ. ഇത് കൺഫർമേഷൻ ഓഫ് സെന്റൻസ്. When you are serving out the sentence, this question will arise. That നിങ്ങൾക്ക് ചില ഡ്യൂട്ടീസ് ഉണ്ട്. It's your duty to inform the court that this man is having a well health or a feeble health. It's your duty to inform the court that we have to safeguard his privacy aspects. So then only the court can reach into a fair conclusion what way the punishment is to be imposed. So you shall not be oblivious of these kind of responsibilities on you. We know that only in certain category of offense it is envisaged as a punishment. But
Now-
still,
Now
defamation,
there are only 6 offences under the BNS which prescribe this punishment, for which this punishment is prescribed. They are: 1. A public servant unlawfully engaging in trade, section 202 of the BNS. A public servant unlawfully engaging in trade, section 202 of the BNS. Then, non-appearance in response to a proclamation, section 209 of the BNS. Section 209 of the BNS. Then, attempt to commit suicide, to compel or restrain exercise of lawful power, section 226. Attempt to commit suicide, to compel or restrain exercise of lawful power, section 226. Then, theft of property less than rupees 5,000 in value upon return of that property by the first time offender. First time offender. Suppose if a person commits theft, the value is less than 5,000, then if he returns that property, the only sentence which is provided under the BNS is community service.
proviso to
The proviso to section 303 2, subsection 2. Subsection 2 of section 303 proviso. Then, misconduct in public by a drunken person, section 355. Section 355. Then, last, defamation. Defamation. Section 356, subsection 2. Subsection 2 of section 356, defamation.
the defamation of that attempt to commit suicide ആ 226 വരുന്ന അതിലുമാണ് നിങ്ങൾക്ക് കൂടുതൽ ഇതിൽ വരാൻ സാധ്യത. ആ ടൈമിൽ നിങ്ങൾ അത് കോടതിയെ അലേർട്ട് ചെയ്യേണ്ടതായ സാഹചര്യം ഉണ്ടാകും. സോ കീപ് ഓൾ ദീസ് തിങ്സ് ഇൻ മൈൻഡ് ഓൾസോ that you have an obligation to the court to inform these aspects to the court when imposes the punishment.
Now, the next important provision is section 25. Section 25. Corresponding provision is section 31 CRPC. Section 31 CRPC. See, a magistrate imposes sentence of imprisonment for more than one offence in a single trial. For example, offences punishable under sections 324 and 448. He imposes sentence of imprisonment for both offences. What the magistrate is expected to do? He should state in the judgment whether these sentences of imprisonment shall run concurrently or consecutively. Suppose he doesn't state so, omitted to do so, it will run consecutively because it is specifically provided under the code section 31.1. Last portion, 31.1. Now, that portion is omitted under the BNSS, section 25.1. Section 25.1. Instead of that, it is stated when a person is convicted at one trial of two or more offences, the court may, subject to the provisions of section 9 of the BNS, sentence him for such offences to the several punishments prescribed therefor, which such court is competent to inflict, and the court shall, the next thing is added, considering the gravity of offences, order such punishments to run concurrently or consecutively. So, what is the consequence of not mentioning? That is not provided under the section 25.1, as in the case of section 31.1 of the code.
Gravity of offences പറഞ്ഞതുകൊണ്ട് നിങ്ങൾക്ക് ഒരു ഡ്യൂട്ടി ഉണ്ട് to argue at that time also whether it should be concurrent or should be imposed consecutively എന്നുള്ളൊരു ആസ്പെക്ട്.
ആ ഒരു ഗ്രാവിറ്റി ഡിറ്റർമൈൻ ചെയ്യുന്നത് എന്തിന്റെ അടിസ്ഥാനത്തിലായിരിക്കാം? ഒരുപാട് ഒഫൻസുകൾ പറയുന്നുണ്ടല്ലോ, മേജർ പണിഷ്മെന്റ്. അതിനകത്ത് ഒരുപാട് പണിഷ്മെന്റുകളും ഒരുപാട് ഒഫൻസുകളും പറയുന്ന ഒരു സാഹചര്യത്തിൽ അതിൻ്റെ ഒരു ഗ്രേവ് ഒഫൻസ് എന്ന് പറഞ്ഞ് പ്രത്യേകമായിട്ടൊരു ഭാഗം ഇല്ലാത്ത സാഹചര്യത്തിൽ അത് എങ്ങനെ ഡിറ്റർമൈൻ ചെയ്യാൻ പറ്റും?
It is left to the discretion of the court, but that discretion has to be exercised judiciously in determining whether that offense is grave or not.
Major
Even still, we are leaving it to the wisdom of the court that how to approach this component, whether that is commensurate to the offense committed or not. Still, it's leaving to the discretion of the court. So similarly, you got some sentences here considering the gravity of offense. Court has to consider that's an obligation on the part of the court, and you have an obligation that you have to argue on that point also.
Now, then suppose during after the trial of a case, a person is convicted for 5 offences. Sentence of imprisonment is awarded for all the 5 offences. Under section 31(2) proviso clause A of the CRPC, it was provided that the total period of imprisonment then shall not exceed 14 years. 14 years. Now that is substituted as under section 25(2) proviso clause A. 20 years. 20 years. 20 years. Now, whether this provision clause A, proviso A, subsection 2 of section 25 applicable to sessions judges trying sessions cases. You see in the newspapers every day the POCSO courts sentencing persons with 60 years, 80 years, 90 years of imprisonment.
140, 160.
The Constitution Bench of the Supreme Court has held that this is not applicable to sessions judges trying sessions cases. AIR 2016 Supreme Court 3340. AIR 2016 Supreme Court 3340. Again, 2021 KSC 662. 2021 KSC 662. Now, one more thing. Whether suppose no minimum sentence is provided, only the maximum sentence of imprisonment is provided for a particular offense. Can he be sentenced to imprisonment till the rising of the court? The courts usually do. But can it be done statutorily? The day before yesterday, the Supreme Court has held that it can be done. The day before yesterday. Imprisonment till the rising of the court. And what does imprisonment till the rising of the court means? So for one day. It is for one day. Is it necessary to send a person to jail to suffer that imprisonment? No. That is also there are decisions. Eh? Whatever be the time. Till the rising for a court, till the rising.
Till the rising of the court.
The court is supposed to rise only to 5 p.m. Day before yesterday. Day before yesterday, Supreme Court judgment Justice C.D. Kumar, till the rising of the court, that is statutorily admissible, can be given. Sentencing policy പറ്റി ഒരു ഡിസിഷൻ വന്നതാണ്. അതെ, അതിനെക്കുറിച്ച് വന്നതാണ്. അതിനകത്ത് ഒരു കൺക്ലൂഷൻ ഇതാണ്, ഒരു ഫൈൻഡിങ്.
That we can break for tea. So because of paucity of time, take 15 minutes or you do the things within that time. Come back after 15 minutes. Let's start by 11:50. So in meantime, the judgments His Lordship referred about these BNSS are with me. that either you can take a copy of these judgments or we will circulate if email is provided, email ID is provided, we will circulate
Under section 531.
530. Welcome back, all of you. We have to move a bit fast also because we have to cover 531 sections.
Now the next important provision is see, as far as the lawyers and the accuser are concerned, section 41 capital letter A of the CRPC is very, very important. Section 41A CRPC. Now, if we simply look into the text, we may not be able to know which is the corresponding provision. But that is provided, corresponding provisions are there under subsections 3 to 6 of section 35. Subsections 3 to 6 of section 35 of the BNSS. Same provisions, no change, but only to make you aware that the provisions under the provisions under section 41 capital letter A of the CRPC are reintroduced as subsections 3 to 6 of section 35, section 35 of the BNSS. So that Arnesh Kumar doesn't go. Arnesh Kumar is still there. So that everybody you are happy.
Ramesh Kumar, Satyendra Kumar, until all are using that.
Now the section 35 subsection 7, that is a new provision. Subsection 7 of section 35. It states, no arrest shall be made without the prior permission of an officer not below the rank of DYSP. In which cases? In case of an offence which is punishable for imprisonment of less than 3 years, and not in respect of all arrest of all persons, but when the person to be arrested is infirm or above 60 years of age. So suppose a person is infirm, or if he is above the age of 60 years, and if the offence allegedly have been committed by him is an offence which is punishable with the imprisonment of less than 3 years, he shall not be arrested without the prior permission of an officer not below the rank of DYSP. Now section 36 small letter C. Section 36 small letter C. See, it deals with the persons. The police officer on arrest of a person should inform that person. He has got a right to inform his friend or relative. That is under the code it is provided. Now one more category is added there. He has a right to have a relative or a friend or any other person named by him to be informed of his arrest. That any other person named, that is added. That is an addition. See, any other person means no qualification is provided. Can be any person which the arrested person names.
നിങ്ങളെ സജസ്റ്റ് ചെയ്താൽ നിങ്ങളെ ആവാം. If a client has confidence,
Now, see, arrest by private person, that is some changes there. We are not much impact. Then next important provision is section 43.3. 43.3. See, nowadays when a person who is in custody is brought to the court, whether the police use handcuffs on him, normally they use. But when the accused is about to enter into the dock, this will be, that is a practice. But the Supreme Court has stated in many decisions that when a person is brought to the court, person in custody is brought to the court, handcuffs can be used only with the prior permission of the court of the magistrate. You may read AIR 1980 Supreme Court 1535. AIR 1980 Supreme Court 1535. Then again, AIR 1996 Supreme Court 2193. AIR 1996 Supreme Court 2193. Now the police is given police is statutorily empowered to use handcuffs. Not on all accused, but the police officer may, keeping in view the nature and gravity of the offence, use handcuff while making the arrest of a person or while producing such a person before the court. Under two circumstances only, while making the arrest, one, or while producing such a person before the court. Not all accused, but who is a habitual or repeated offender, or who escaped from custody, or who has committed offences of so and so mentioned in that provision. This is the police officer can decide whether to use handcuffs or not. Then see on what basis he should decide. Keeping in view the nature and gravity of the crime. So the Supreme Court has but stated some guidelines to the magistrate in those decisions. When the magistrate can grant permission. Suppose a person is violent or he is likely to escape a tendency, then he may cause a danger to himself or other persons. In such circumstances, the Supreme Court says magistrate can grant permission. എന്താണ് സുപ്രീം കോടതി ഇങ്ങനെയാണ് പറയുന്നത്, സേവ് ഇൻ റെയർ കേസസ് ഓഫ് കോൺക്രീറ്റ് പ്രൂഫ് റിഗാർഡിംഗ് proneness of the prisoner to violence, his tendency to escape, he being so dangerous or desperate, and the finding that no other practical way of forbidding escape is available, the magistrate may grant permission to handcuff the prisoner. But what are the criteria here for a police officer, keeping in view of the nature and gravity of a crime? So, if a person commits a grave crime, that doesn't mean that he should be a violent person or he may cause a danger to himself or others. Always, it doesn't mean so. But here the criterion is keeping in view of the nature and gravity. That is something to be, and that too, the discretion of the police officer. See, Supreme Court itself has stated, merely because the offence is serious, the inference of escape proneness or desperate character doesn't follow. Merely because a person has committed murder, that doesn't mean that he is a desperate person. So that is now gone, and this is provided. Now, section 51(1), medical examination of an arrested person, an accused at the request of the police officer. Section 51(1). Earlier, this request for medical examination should have been made under the code by a police officer not below the rank of sub-inspector. Not below the rank of sub-inspector under the code. Now under 51(1), any police officer. Now section 51(3), that is a new provision. The registered medical practitioner shall, without any delay, forward the examination report to the investigating officer. Now, in case of section 52(1), medical examination of a person accused of rape, there also, under the code, the request should have been made by a police officer not below the rank of sub-inspector. Now, it is any police officer. Now, this medical examination of accused is very, very important, especially in case of rape cases where the victim is dead. The medical examination will be very, very important of an accused person, and collection of DNA samples also. Because in case if the victim is alive, of course, the testimony of that victim will be there, and it will be given credence by the court. But when the victim is dead, there may be only circumstantial evidence then, in many cases. Then this becomes very, very important. And in certain cases, the Supreme Court has held that absence of collection of DNA from the accused is fatal. But in certain cases, Supreme Court has held that no, it may not be so in all cases. I will give three decisions you can use according to the circumstances. That is first one, AIR 2022 Supreme Court 2396. AIR 2022 Supreme Court 2396. Then AIR 2022 Supreme Court 4688. AIR 2022 Supreme Court 4688. Then AIR 2019 Supreme Court page number 1. AIR 2019 Supreme Court page number 1. Now, section 53. 53, the first proviso, 53(1), first proviso. That is something new. Provided that if the medical officer or the registered medical practitioner is of the opinion that one more examination of such person is necessary, he may do so. So, the medical officer can conduct more than one examination. Now, section 54 of the BLSS. There is only a slight change. Under section 54 capital letter A of the code, that is a corresponding provision, it was provided that when a judicial magistrate conducts the identification parade, when the witness is a physically or mentally disabled person, the process shall be videographed under the code. Now that videograph, that is substituted as shall be recorded by any audio, video, electronic means. Not only videography, but shall be recorded by any audio, video, electronic means. Why I stated this is, in many of the subsequent provisions where it shall be videographed, that expression was used under the code, that has been changed as by any audio, video, electronic means. If you, regarding the identification parade, if you want regarding the identification parade, I want to bring to your notice a recent decision of the High Court. See, in our state, there is no practice of conducting identification parade of properties, only persons. No practice of conducting identification parade of properties. Now, recently, a division bench of the High Court of Kerala has held that, especially when the victim is dead, if the victim is alive and suppose a robbery is committed and the ornaments are recovered, she may be able to identify. No identification parade may be necessary, because the Supreme Court has in one case held that the ladies have got uncanny knack of identifying her own belongings. ladies uncanny. The ladies have got an uncanny knack of identifying her own belongings. So that may not be necessary when the victim is alive. But when the victim is also dead, and suppose other persons are supposed to say these recovered ornaments belong to the victim. Our High Court says conducting an identification parade of the properties, which is the practice in some other states. That should be there. That is, I will give you the citation. That is 2024 KSC Online 571. 2024 KSC Online 571. And what are the requirements a magistrate has to comply with while conducting an identification parade? That is a recent decision, not so recent, but that is an important decision. You may also note that is 2023 1 SEC 180 from Kerala. That is a decision from Kerala, arising from a case from Kerala. 2023 1 SEC 180. Now section 58 of the BLSS. Production of an arrested person before the magistrate within 24 hours, corresponding to section 57 CRPC. And there is only one change. Earlier under the code it was not provided that this magistrate should have jurisdiction or not. That is not provided. Now it is provided, the last portion of section 58. Whether having jurisdiction or not. Whether having jurisdiction or not. That is in consonance with Article 22 of the Constitution, which says he shall be produced before the nearest magistrate. Before the nearest magistrate. Whether having jurisdiction or not. Now the next important provision is section 63. It is a form of summons. As you know, under the code, section 61 provided that a summons shall be in writing, in duplicate, signed by the presiding officer or an authorized officer, and it shall bear the seal of the court. That was provided under the code in writing. That is still retained. But another form is also given. What is that? That is e-summons. In an encrypted or any other form of electronic communication, and shall bear the image of the seal of the court or digital signature. That is e-summons. Right here. Now, somebody from Trivandrum district. There a new system has been introduced by the High Court now for sending not summons, not only summons, communications through e-post. At present only in Trivandrum district, but it will be extended to other districts also during the course of the time. And I think judicial officers have been given, judicial officers have been alerted about that by the High Court. Now the proviso to, sorry. So, the proviso to section 64(1). (64)(1) says every summons shall be served by a police officer subject to rules so and so. Then, provided that the police station or the registrar in the court shall maintain a register to enter the address, email address, phone number, and such other details as the state government may by rules provide. That is a new provision. A register has to be kept with regard to the summonses sent. Already there is a mandate that there should be a register with regard to the warrants. That is in accordance with the direction of the Supreme Court. Now, there are slight changes in the subsequent provisions regarding service of summons on corporation company, on whom it can be, and in case of a firm, on whom it can be, etc. I am skipping those provisions. Then, one important change I will mention, that is section 66 of the PNSS. 66. See, under the code, when a police officer goes to the house of an accused with a summons, and when he reaches there, the accused is not in his house, but his wife is there. Can the police officer serve the summons on the wife? Then, under the code, no, because male person. Now, under section 66, that male is omitted. That male is omitted. Some adult member of his family residing with him. Now, section 70, subsection 3. That is a new provision. It states, all summons served through electronic communication under sections 64 to 71, both inclusive, shall be considered as a duly served, and a copy of such summons shall be attested and kept as a proof of service of summons. See, all summons served through electronic communication shall be deemed to be duly served. But what should be the proof of service? What should be the proof of service? That is a different thing. Proof of service. വാട്സപ്പിലാണെങ്കിൽ ഡബിൾ ടിക്ക് വന്നാൽ മതിയോ?
ഇമെയിൽ ആണെങ്കിൽ എന്ത് ചെയ്യും?
Nothing is provided, I think, in the BNSS with regard to that proof of service. Then we can usually adopt some rules or something comes on. We can usually adopt section 13 subsection 2 of the Information Technology Act, which provides the service of e-communications. Section 13 subsection 2 of the Information Technology Act. You may read that. There is no time to discuss that. That is why. And if you want to know more about section 13.2 of the Information Technology Act, you may also read decision by the Allahabad High Court, that is 2024 AHC 80741. 2024 AHC 80741. What is this? Anybody knows? Lawyers are in the.
HSC journal.
What is the KER as far as Kerala is concerned? 2023 KER dash number. What is that?
KER. KER.
That is a neutral citation number of the Kerala High Court. KER which varunnu. See, you can go to the website of the High Court, then you get many options. You click judgment and orders, then you get many options. There you get neutral citation number, many options. One of them is neutral citation number. Click on that. You give this number. The judgment will be there, order will be there. You can download it, take print of it, anything. You can produce it before the court. That is there. This is the neutral citation number of Allahabad High Court. Allahabad High Court സൈറ്റിൽ ചെന്നിട്ട് ഈ ന്യൂട്രൽ സൈറ്റേഷൻ നമ്പറിലെ ഓപ്ഷൻ എടുത്തിട്ട് ഇത് അടിച്ചു കൊടുത്തു കഴിഞ്ഞാൽ ജഡ്ജ്മെന്റ് കിട്ടും. 2024 ASC 80741. The learned director says you may give the names of the parties. This is Rajiv Malhotra, RAJIV, RAJIV. Next word Malhotra, MALHOTRA. Rajiv Malhotra versus State of UP. Then
ഈ presumption apply ചെയ്താൽ കോടതി നിങ്ങൾ ആരും ഒബ്ജക്ട് ചെയ്യാതിരിക്കാൻ വേണ്ടിയാണ്. This is because it's statutorily permitted also. 13.2 because 2.2 you have to apply 2.2 and then comes the court can draw a presumption under section as permitted under section 13.2.
now section 84 subsection 4. Proclamation. There, earlier, certain offences were mentioned under section 82.4 of the code. Corresponding provision ആണ് 84.4. ആ ഒഫൻസസ് മാറ്റിയിട്ട് ഇപ്പൊ പകരം ഒരുമിച്ച് അത് പറഞ്ഞു. എങ്ങനെയാണ്? offense which is made punishable with the imprisonment of 10 years or more, or imprisonment for life, or with death under the BNS or under any other law for the time being in force. This has got some significance when we come later, when we later deal with some another provision. Proclaimed offender. Now, section 86, that is a new provision. You may read that. That is the attachment of property, identification of the property of a proclaimed offender abroad. Section 86. Then section 94. See, it is corresponding to section 91 CRPC. Under section 91 CRPC, if a court of a police officer finds that it is necessary or desirable to produce, direct a person to produce two matters. What are they? Produce a thing or a document or a thing. Section 91 CRPC. The court can direct. Corresponding provision section 94 CRPC, something is added a third category, that is electronic communication. Not mere electronic communication, but electronic communication including communication devices. That means a laptop or a mobile phone which is likely to contain digital evidence. Any electronic device which contains electronic communication, the court can. That is a change there. And it can be directed to be produced either in physical form or in electronic form. Communication മാത്രമാണെന്നുണ്ടെങ്കിൽ they can be in electronic form, directed to be produced. Now, whether any direction can be given to an accused person to produce a thing or something under section 9, earlier section 91 CRPC, now to section 94. Anyway, it is a debatable point, but a constitution bench has held that section 91 of the code is not applicable to an accused person. That is AIR 1965 Supreme Court 1251. AIR 1965 Supreme Court 1251. Now, self-incrimination. 91 ആയാലും 94 ആയാലും പ്രിൻസിപ്പിൾ സെയിം ആണ്. ഇതിനകത്ത് 94 ഒരു കാറ്റഗറി കൂടി ആഡ് ചെയ്തു പ്രൊഡ്യൂസ് ചെയ്യാൻ പറയുന്നില്ല, അത്രേ ഉള്ളൂ.
ഹാൻഡിൽ ചെയ്തിട്ടുണ്ട്. അപ്പോൾ ആ സാഹചര്യത്തിൽ അതിന്റെ CCTV ഫുട്ടേജ് അക്യൂസിന് പ്രൊഡ്യൂസ് ചെയ്യാനായിട്ട് ആവശ്യപ്പെടാൻ പറ്റില്ലേ കോടതിയിൽ? CMP ഫയൽ ചെയ്തിട്ട്
ഏത് സ്റ്റേജിൽ?
ക്രൈം സ്റ്റേജിൽ.
It is difficult as per the present provision, but in my view, that can be done. There are certain decisions, I cannot straight away give the citation because that is not with regard to change. There are certain decisions which say that though you have got no right at that time to summon documents or documents, even at the time of framing charge, you have no right. Devendra Nagapati, 3 judgments. Though that is the position, in respect of these type of evidence, that is digital evidence, it is likely to be lost. ഇപ്പോൾ CCTV ഫുട്ടേജ് ആണെങ്കിൽ ചിലപ്പോൾ അതിൻ്റെ ആ ടൈമിൽ ഇതുണ്ടാവും, അത് കഴിഞ്ഞാൽ പിന്നെ കിട്ടില്ല. അതുപോലെ തന്നെ മൊബൈൽ ഫോൺ ഡാറ്റ ആണെന്നുണ്ടെങ്കിൽ അവർ കമ്പനിയായിട്ടുള്ള എഗ്രിമെന്റിന്റെ അടിസ്ഥാനത്തിൽ ഇറ്റ് മേ ബി 1 year or 2 year, whatever it be. So there are some decisions which say that you can ask the court to summon it and keep it there in sealed cover. And when it is required for the purpose of your defense evidence, it can be done. The purpose is only this much. By lapse of time, it will not be lost. That is the present position. Even at the time of raising charge, you cannot do that. Then how can it be before that? Supreme Court has stated that we will come to that decision later. Debendranath Padi versus State of, I think, Odisha. I don't correctly remember now. Huh? So that is even recently, day before yesterday, Supreme Court held at the time of framing charge, the accused has no right to produce documents or summon documents. Day before yesterday. That is a decision. Then, relying upon this, Debendranath Padi, that also. Then, I want to ask you a question. Suppose regarding, I already said, directing an accused to produce something, incrementing, that is a debatable point anyway. Now, whether it can be done under Section 91 or Section 94 here. But can the investigating officer direct an accused to furnish the password of the mobile phone or the laptop? This mobile phone or laptop was seized by them during search. Then they want to open it. Password is necessary. Only the accused knows it. Can the investigating officer direct the accused to produce it, furnish it? The Karnataka High Court has discussed everything with regard to this thing and self-incrimination, etc. And found that he can direct. Because the password by itself, it is not self-incriminating. Like finger impressions or fingerprints. State of Kadikalu versus State of Bombay. 11 judge ruling. That Karnataka High Court decision I will give you, that is 2021 SCC online Karnataka 5032. 2021 SCC online Karnataka 5032. I will also give you the names of the parties so that from other sides, if you may find out. Virendra, Virendra. Virendra. അടുത്ത വേർഡ് ഖന്ന, KHANNA, ഖന്ന versus State of Karnataka.
വായിച്ചു നോക്കുന്നത് നല്ലതാണ്. അതിൽ സെക്ഷൻ 27 ഒരു ആസ്പെക്ട് കൂടും. അതായത് ദി സ്റ്റാൻഡ് അമൗണ്ട് ടു എ ഡിസ്കവറി ഓഫ് ഫാക്ട് അണ്ടർ സെക്ഷൻ 27.
Now, with regard to Section 91 CRPC, there is a recent ruling of our High Court that only when the court finds that it is desirable or necessary, that it shall be directed to be, something shall be directed to be produced. That is 2024 KER, that is a neutral citation, 2024 KER 50586, 2024 KER 50586. Corresponding KSC I will give you. 2024 KSC online 593. 2024 KSC online 593. Now the next important provision is section 105. That is a new provision regarding attachment of property. I'm sorry. Regarding conducting of search and seizure. It states the process of conducting search of a place or taking possession of any property, article or thing under this chapter or under section 185, including preparation of the list of all things seized in the course of such search or seizure, and signing such list by the witnesses, shall be recorded through any audio, video, electronic means, preferably by mobile phone, and the police officer shall, without delay, forward such a recording to the magistrate concerned. So, search of seizure നടത്തിക്കുമ്പോൾ റെക്കോർഡ് ചെയ്യണം, ഓഡിയോ, വീഡിയോ, ഇലക്ട്രോണിക് മീൻസ്, പ്രിഫറബിളി ബൈ എ മൊബൈൽ ഫോൺ. റെക്കോർഡ് ചെയ്താൽ മാത്രം പോരാ, പിന്നെയോ വിത്തൗട്ട് ഡിലേ it shall be what? The recording shall be forwarded to the magistrate concerned. How it will be done? മൊബൈൽ ഫോണിൽ എടുക്കുക, മജിസ്ട്രേറ്റിന്റെ മൊബൈൽ ഫോണിൽ അല്ലേ? So if a copy is taken, that may be copy, then you will at the time of trial raise all objections. 65B certificate, other certificate, that certificate, this certificate, etc. Not admissible, etc. So this is something to be looked into. I think the Union Home Ministry has issued some guidelines with regard to this. Anyway, that is the attack of the police officers. Why this provision is introduced? That is the important thing. To give transparency to the process of search and seizure. That is the idea. Now, under the provisions of the code, whether a police officer can attach immovable property during investigation. Immovable property attach ചെയ്യാം. Investigation stage police officers. Supreme Court has held that they cannot, because that is AAR 2019 Supreme Court 4554. AAR 2019 Supreme Court 4554. Now a new provision is added, 107, for attachment of property, not by the police officers but through the court. There are subsections 1 to 8 to that provision, I will deal with the subsection 107.1. The rest you can read and understand. Where a police officer making an investigation has reason to believe that he should have reason to believe. Believe what? That any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of any offense. He may, with the approval of the superintendent of police or the commissioner of police, make an application to the court or the magistrate exercising jurisdiction for attachment. So that can be now done. Then comes the provisions with regard to how it can be done ex parte also. At the initial stage. If subsequently the accused comes and after hearing his objections, it can be withdrawn. Or even a third party can say that it is my property, it is not liable to attachment. It is just like something, Order 38, Rule 5, not similar, but more or less that thing is there. Then under the criminal statutes, for example, PMLA, there is a designated authority for attachment, not by through the court. Then or under the Criminal Law Amendment Ordinance 1944. Criminal Law Amendment Ordinance 1944. 1944 ആണ് ഇതിന്റെ ഇപ്പൊ നിലവിലില്ലാത്തൊരു നിയമത്തെ കുറിച്ചാണ് ഞാൻ പറയുന്നതെന്ന് കരുതണ്ട. ഇറ്റ് ഈസ് സ്റ്റിൽ ഇൻ ഫോഴ്സ്. Sum and substance is that this provision enables an investigating officer to attach proceeds of crime through the process of the court. And regarding the PMLA, when it will not amount to proceeds of crime. If you are interested, you may read, because it will have some implications when you consider section 107. Proceeds of crime അല്ലാന്ന് എങ്ങനെ സ്ഥാപിക്കാൻ പറ്റുന്നുള്ളത് പലതിലും. That is a recent decision of the High Court of Kerala in PMLA 2024 KSC Online 550. 2024 KSC Online 550, and in the latest KSC that is printed also. കഴിഞ്ഞ ആഴ്ചത്തെ KSC പ്രിന്റ് ഉണ്ട്. 2024 4 KSC നമ്പർ ഐ ഡോണ്ട് റിമെമ്പർ. പ്രിന്റിൽ വന്നിട്ടുണ്ട്. By Justice Peju Kujan Thomas.
This Butts Act also.
There are Butts Act. There is this attachment of property. Whether a police officer can freeze the bank account of a person during investigation. It can be done. 1999 7 SEC 685. 1999 7 SEC 685. Now section 144. Corresponding provision section 125, maintenance. under section 144(1), a slight change is made, provided that, and the provided that the magistrate may order the father of a female child, minor എന്നുണ്ടായിരുന്നു omit ചെയ്തു. ഞാനിത് റെഫർ ചെയ്യാൻ കാരണം എന്താണെന്ന് വെച്ച് കഴിഞ്ഞാൽ ഇനി പല പ്രൊവിഷൻസിലും നമുക്ക് കാണാം, അത് പ്രത്യേകം ഞാൻ പറയില്ല. അതുകൊണ്ടാണ് എന്താണ് ഈ മൈനർ എന്നോ അല്ലെങ്കിൽ എ പേഴ്സൺ അണ്ടർ ദി ഏജ് ഓഫ് 18 years എന്നോ പറഞ്ഞിടത്തെല്ലാം തന്നെ അത് സബ്സ്റ്റിറ്റ്യൂട്ട് ചെയ്തിട്ട് ചൈൽഡ് ആക്കി. ചൈൽഡ് why that? Under the BNS, now the definition of child is given a person under the age of 18 years. Now, as you are aware, the decision of the Supreme Court last week, any divorced Muslim woman can claim maintenance under section 125 CRPC in spite of the special statute. In spite of the special statute there.
Particular section. Father or mother resides. Jurisdiction awarded.
ഒന്നാമത് ഇത് ഫാമിലി കോർട്ടിലാണ്. എന്താണ്?
Is that decision not against the statute?
You can have your own opinion, but once the Supreme Court says it is binding on all of us, at least courts, you can have your own opinion. Now, section 153 CRPC that dealt with inspection of aids and measures by the police. No corresponding provision under the BNS because of the special act regarding standards of weights and measures, something like that.
So let's take the lunch break. Because we are the next provision is needs some kind of detailed discussion, so that we can take the lunch break. And the lunch break is 5 minutes ahead of the schedule, so you return by 1:50, so that we can commence the
150, 150.
150, not 115. Yes, so that we can commence the afternoon session by that.
Welcome back. Now, under the code, which is a provision which deals with the registration of FIR, section 154, subsection 1. Now, the corresponding provision is section 173(1) of the BNSS. Now, there are two changes brought in under section 173(1) of the BNSS. I will deal with the one by one. The provision states every information relating to the commission of a cognizable offence. Then the next thing is an addition. Irrespective of the area where the offence is committed. That is an addition. See, normally, suppose an information regarding a cognizable offence is given to a police station by somebody through, suppose it is through phone. They will ask first, where is the place of occurrence? If it is not within their jurisdiction, they will normally redirect the informant to call the concerned police station. But that was a practice deprecated by the Supreme Court as early as in 1990s. That is, AR 1993, Supreme Court 2644. AR 1993, Supreme Court 2644. Supreme Court states any lack of territorial jurisdiction could not have prevented the police officer from recording information about the cognizable offence and forwarding the same to the police station having jurisdiction over the area in which the crime was said to have been committed. So the Supreme Court had stated that even if the information relates to an offence committed beyond the area of the police station where it is received, they are bound to register an FIR, then they will have to forward it to the police station concerned. That was what was stated in AR 1993, Supreme Court 2644. This is called zero FIR, though that expression is not used in that decision. Now, if you want to know the difference between a normal FIR and a zero FIR, it is very simple. In very simple language, it is stated by the Delhi High Court in a decision, that is 2022 Criminal Law Journal 539 Delhi. 2022 Criminal Law Journal 539 Delhi. Corresponding citation 2022 KSC 2382. 2022 KSC 2382. So this is called zero FIR. That is, suppose information is regarding a cognizable offence is given to a police station which has no jurisdiction or territorial limits of jurisdiction over the area where the offence was committed. Then they will have to register an FIR. Then they will have to forward it to the police station concerned having jurisdiction. Now this concept of zero FIR is given statutory recognition under section 173(1) of the BNSS. But there also there is some lacuna. There is no provision which says after registration of the FIR in such a case, it has to be forwarded to the police station having jurisdiction. That is not provided. It means that the same police officer, the officer in charge of the same police station where it is registered may conduct investigation. And in one or two cases, the Supreme Court has also stated that merely because the police officer, such a police officer conducts investigation, it cannot be termed as illegal and it cannot be interfered with. Maybe that may be the reason. Then that is zero FIR. Now we come to EFIR. EFIR. Every information relating to the commission of a cognizable offence, irrespective of the area where the offence is committed, may be given orally. Orally ennulladu codiluണ്ട്. Then something is added. Or by electronic communication. Information can be given through electronic communication to an officer in charge of a police station, and if given orally, it shall be reduced to writing by him or under his direction and be read over to the informant. And every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it. Now, what about the information received through e-communication? That is provided next, that Roman letter 2. If it is received by electronic communication, it shall be taken on record by the officer in charge of the police station on being signed within 3 days by the person giving it. So the FIR will be then registered only when the informant signs it, the information given within 3 days. So in a way speaking, why this provision is introduced to enable a person to give information through electronic communication? He need not go to the police station, wait there till the SHO comes. So that we are able to avoid that trouble. That is the advantage. Then he can give the information from a distant place. Now, please. Now, that advantage is in a manner nullified by the second limb, which says that it shall be signed within 3 days. See, it doesn't state that the informant should go to the police station and sign it. It is not stated. Correct, true. But no police officer will go to the house of the informant and get it signed. Normally. So that is there. Then there are other problems also. Suppose this is not signed within 3 days. What is the consequence? Now FIR will be there. Does it mean that if it is a grave crime, suppose, police officer should not investigate it? That is another problem. Suppose he goes to the police station the fourth day to sign it. Whether they will allow him to sign it, permit him or not, ചെയ്യാൻ സമ്മതിക്കുമോ അറിയോ അല്ലെങ്കിൽ സമ്മതിക്കാമോ? So these are some problems areas. Of course, need interpretation by the constitutional courts so that we will get clarification or something definite. Then, suppose this e-communication given to the police station contains a digital signature, then is it necessary that it should be signed? Right? എൻ്റെ മുമ്പത്തെ ക്ലാസ്സിൽ പങ്കെടുത്തിട്ടില്ല ആരെങ്കിലും? ആ അതിനകത്ത് വന്നിട്ടില്ലല്ലോ. Why? Because in section 5 of the IT Act, it is stated that whenever any law states that a document should bear signature, electronic signature is sufficient. Electronic signature is sufficient. Section 5 of the IT Act. That is there, but that is not specifically provided here. Then ഈ ഇലക്ട്രോണിക് കമ്മ്യൂണിക്കേഷൻ എന്നുള്ളതിൽ എൻ്റെ ഡെഫിനേഷൻ വായിച്ചപ്പോൾ ഞാൻ പറഞ്ഞു ദാറ്റ് ഇൻക്ലൂഡ്സ് ടെലഫോൺ ഓർ മൊബൈൽ ഫോൺ. At that time, I also stated that this has got some significance. Suppose before this BNSS, if somebody gives information through telephone or mobile phone, and if the information is very clear, no vagueness, regarding the commission of a cognizable offense, the police officer is expected to register an FIR on the basis of that. Suppose now after 1/7/2024, if an information is given through telephone or mobile phone, whether the police officer should consider it as e-communication or normal oral communication. Because the electronic communication includes, we have seen the definition, telephone or mobile phone, and the oral, verbal, written, pictorial. That is one. That is also there. That is there. Can be. That the police officer will decide. They can very well say that this is only on being signed within 3 days. That is also provided if it is through e-communication. Anyway, this is also a matter which may come up before the constitutional courts for interpretation. Now, anyway, the Ministry of Home Affairs have issued a SOP, and this SOP, Standard Operating Procedure, Standard Operating Procedure to the officers, etc., with regard to the procedure to be adopted. Now, Now the next provision. So these are the two changes. One, it gives statutory recognition to zero FIR. Then the other, it gives statutory recognition to EFIR. Now subsection 2. A copy of the information as recorded under subsection 1 shall be given forthwith, free of cost, to the informant. അത്രയും കോഡിലുണ്ട് 154(2). Then the addition, or the victim. There also it is or. So an informant goes to the police station, FIR is registered, he is given free copy. The next day the victim goes to the police station, asks a free copy. Will he be given? Will he be given? Informant or the victim. In my view, it should have been and victim. Then the Supreme Court has held that this provision is not mandatory but only directory. It is free of cost in the FIR copy. That is AIR 2013 Supreme Court 3673. AIR 2013 Supreme Court 3673. Then a very recent decision last week, I think it is on 8/7, that is Supreme Court has stated that I will give you the citation. Not only this giving free copy, but the formalities under section 154(1), now current 173(1), certain formalities. That is 2024 INSC. What is that? Supreme Court സൈറ്റിൽ പോയാൽ കിട്ടും INSC. മറ്റേ റിപ്പോർട്ട് വന്ന ഓൺലൈനിൽ കാണും. 2000 KFC ഓൺലൈനിൽ വന്നതാണ്. 2024 INSC 480. I will give you the name of the party so that you can search it out from KFC online. Dharmendra DHARMENDRA. അടുത്ത വേർഡ് കുമാർ വേഴ്സസ് സ്റ്റേറ്റ് ഓഫ് മധ്യപ്രദേശ്. What the Supreme Court says is this: if the police had failed to read out or apprise the informant about the contents of the FIR, it would not be fatal to the prosecution case unless it is shown that it has caused prejudice to the accused. The stipulations outlined in section 154 CRPC concerning the reading over of the information after it is written down, the signing of the said information by the informant, that is important, the signing of the said information by the informant, and the entry of its substance in the prescribed manner are not obligatory. Now section 173(3). That is a new provision. Without prejudice to the provisions contained in section 175, on receipt of information relating to the commission of any cognizable offence, which is made punishable for 3 years or more, but less than 7 years, the officer in charge of the police station may, with the prior permission from an officer not below the rank of DYSP, considering the nature and gravity of the offence, 1. Proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days, or 2. Proceed with the investigation when there exists a prima facie case. So it provides for preliminary inquiry. In certain offences, that is, when an offence is made punishable with what? Punishable with what? അത് അവിടെ കാണില്ല, പ്രൊവിഷനിലില്ല. Which is made punishable for 3 years or more, but less than 7 years. അങ്ങനെയുള്ള കേസസിൽ with the prior permission, he can conduct a preliminary inquiry concerning the nature and gravity of the offence. എന്തിനു വേണ്ടി? That is also stated there. To ascertain whether there exists a prima facie case for proceeding in the matter. So, whether this preliminary inquiry has to be conducted before registration of FIR or after registration of FIR. Before registration, നിങ്ങൾ പറയുന്നത് ലളിതാകുമാരി മനസ്സിൽ വെച്ചുകൊണ്ടാണ്. ലളിതാകുമാരി only says if information received is vague, the preliminary inquiry may be conducted only to ascertain whether any cognizable offence is disclosed. Here that is not. Here what is stated is to ascertain whether there exists a prima facie case. അത് രണ്ടും തമ്മിൽ ഡിഫറൻസ് ഇല്ലേ? So how can it be said before registration? Not only that, it can be made when the offence is punishable with imprisonment of for 3 years or more but less than 70 years. അപ്പോൾ അങ്ങനെയുള്ള ഒരു ഒഫൻസ് ആണ് എന്ന് വ്യക്തമായി മനസ്സിലാക്കത്തക്ക വിധമുള്ള ഇൻഫർമേഷൻ കിട്ടിയിട്ടുണ്ടെങ്കിൽ how can one say that it does not disclose any cognizable offense? Cognizable offense disclose ചെയ്താൽ ലളിതകുമാരി എന്താ പറയുന്നത് FIR should be registered. The preliminary inquiry is only for ascertaining whether it discloses cognizable offense. Anyway, it is a debatable point whether it is before or after. ഉണ്ടാവും. അതിപ്പോ മറ്റേ ലളിതകുമാരി അനുസരിച്ചുണ്ടല്ലോ ഉണ്ടല്ലോ. No. So that is a debatable point. Again, this will have to be interpreted by the constitutional courts. Then now next to section 173(4). Under the code, suppose a police officer doesn't register FIR on giving information regarding a cognizable offense, the aggrieved party can send the substance of his complaint through by post to the superior officer concerned. And the code also provides that it can be sent to the superior officer, and then he may cause the FIR to be registered. That is what is provided under the code. That is here also under section 173(4) provides. But there is an addition there. Suppose the superior police officer also doesn't take any action on the information, then it says, failing which such aggrieved person may make an application to the magistrate. An application. സാധാരണ സുപ്രീം കോടതി റൂളിംഗ്സ് അനുസരിച്ച് നമ്മളൊക്കെ പഠിച്ചിട്ടുള്ള എന്താണ് FIR അവർ രജിസ്റ്റർ ചെയ്യുന്നുണ്ടെങ്കിൽ what is the next remedy? To approach the magistrate with a private complaint. With a complaint. But here it says an application to the magistrate. Whether that an application for issuing direction to the police for registration of FIR, and this is also to be something to be interpreted. Now, before dealing with the next provision, we will come to the continuation of this provision. We will get the continuation of this provision under section 175(3). Under section 175(3). 175(1), as in the case of section 156(1) of the code, provides for investigation into a cognizable offence by a police officer. And earlier section 156(3) of the code provided that any magistrate empowered to take cognizance can order an investigation as mentioned in subsection 1 of section 156. 156 1-ൽ പറയുന്ന പോലത്തെ ഒരു ഇൻവെസ്റ്റിഗേഷൻ മജിസ്ട്രേറ്റിന് ഓർഡർ ചെയ്യാം. അത്രേ പറയുന്നുള്ളൂ 156(3). Now corresponding provision is section 175(3). Any magistrate empowered under section 210 means corresponding to 190 of the code taking cognizance. Then may, after considering the application supported by an affidavit, this is the application earlier referred to, made under subsection 4 of section 173. ക്ലിയർ ആയിട്ട് പറയുന്നുണ്ട് ആ ആപ്ലിക്കേഷൻ. പിന്നെ ഇവിടെ ഒന്നും കൂടി ചേർത്തു എന്ന് മാത്രം. എന്താണ്? ആപ്ലിക്കേഷൻ സപ്പോർട്ടഡ് ബൈ an affidavit. An affidavit. That affidavit is insisted by the Supreme Court in the case of anybody? പറഞ്ഞോളൂ. പ്രിയങ്ക ശ്രീവാസ്തവ. That is AIR 2015 Supreme Court 1758. Priyanka Srivastava versus State of UP. AIR 2015 Supreme Court 1758. There also the Supreme Court uses the word application under section 156(3). Then ഇനി പിന്നെ എന്തെല്ലാമാണ് മനുഷ്യർക്ക് ചെയ്യേണ്ടത്? And after making such enquiry as he thinks necessary, he should make an enquiry. What is the scope of that enquiry? We don't know. Then, and submissions made in this regard by the police officer. The magistrate has also to consider the submissions made by the police officer. Which police officer? Which police officer? We can assume that it is the police officer who refused to register the FIR. Order such an investigation as above mentioned. So, by this provision, the ambit and scope of the earlier provision under section 156(3) of the code are curtailed, circumscribed. The power of the magistrate under section 175(3) is very much now curtailed, limited, circumscribed. Earlier it was only stated that any magistrate empowered can order investigation as mentioned in section 156(1). Now these prerequisites are there under section 175(3). Though the Supreme Court had stated in many decisions that even at that time, before forwarding a complaint to the police under section 156(3), there should be application of mind by the magistrate to see that there is a cognizable offence involved. The complaint contains ingredients, allegations regarding commission of a cognizable offence. Anyway, these preconditions or prerequisites are added there now. And in my view, it is now circumscribed. The power of the magistrate is very much limited now. Only after satisfying these conditions, he can now order an investigation. Then, these things are necessary when the person accused of the offence is an ordinary person. Suppose he is a public servant, then comes the next subprovision, section 173(4). Any magistrate empowered under section 210 may, upon receiving a complaint, there the expression used is complaint, against a public servant arising in course of the discharge of his official duties. വീട്ടിൽ വഴക്കുണ്ടാക്കിയതിന്റെ കംപ്ലൈന്റ് പോരാ. Complaint should relate to something relating to his official, in the discharge of his official duties. During the course ആണ് പറയുന്നത്, arising in the course of the discharge of duties. Order investigation. Then also he can order investigation by can. But there are also two conditions. One, receiving a report containing facts and circumstances of the incident from the officer superior to him. He should obtain a report from the superior officer of the public servant. For what? Ultimately, to decide whether an investigation should be ordered. So this superior officer may or may not have direct knowledge. Suppose sometimes he may be in the cabin. The incident might have occurred in the section. Or a traffic constable may be doing duty outside in the street. His superior officer may be in the traffic police station. Then he may not have any direct knowledge, but his report should be obtained. Then what is the scope of considering this report? We don't know. What the magistrate should do? Suppose the report says no, there is no lapses on this part of the public servant. Whether the magistrate should accept it as a gospel truth, we don't know. Then, not only that, and the second requirement, after consideration of the assertions made by the public servant as to the situation that led to the incident so alleged. ഈ ആരോപിക്കപ്പെടുന്ന സംഭവം ഉണ്ടാകാനിടയായ സാഹചര്യത്തെ കുറിച്ച് ആ പബ്ലിക് സർവന്റിന് എന്താണോ പറയാനുള്ളത് അത് കൺസിഡർ ചെയ്യണം. That also for what? To order an investigation. So this additional protection is given to a public servant. No. Now we come back to the previous provision. That is section 174. Non-cognizable offense. There is only one important change, that is 174(1), another Roman letter 2. Roman letter 2. ഈ കോഗ്നൈസബിൾ ഒഫൻസിന്റെ ഇൻഫർമേഷൻ കിട്ടിക്കഴിഞ്ഞാൽ അത് എൻ്റർ ചെയ്തിട്ട് forward the daily report of all such cases fortnightly to the magistrate. റിപ്പോർട്ട് ഡെയിലി ഉള്ളതായിരിക്കണം, പക്ഷെ അത് ഒരുമിച്ച് 2 ആഴ്ച കൂടുമ്പോൾ മജിസ്ട്രേറ്റിനയക്കണം. Now, I may say one more thing. This Priyanka Srivastava's requirement that an affidavit should be filed in support of the complaint. The word used is application. That was reiterated by the Supreme Court in 2022 5 SCC 639. 2022 5 SCC 639. Now there are certain changes in the other sections. I will skip. Now I will come to section 176.3. 176.3. That is a new provision. On receipt of every information relating to the commission of an offence which is made punishable for 7 years or more. Punishable with what? Where is it stated? Where is it stated? On receipt of every information relating to the commission of an offence which is made punishable for 7 years or more, the officer in charge of a police station shall, from such a date as may be notified within a period of 5 years by the state government in this regard, cause the forensic expert to visit the crime scene to collect the forensic evidence in the offence, and also cause videography of the process on mobile phone or any other electronic device. പക്ഷെ 5 കൊല്ലത്തിനകം വേണമെങ്കിൽ സ്റ്റേറ്റ് ഗവൺമെന്റ് നോട്ടിഫിക്കേഷൻ ഇറക്കാം. ആ നോട്ടിഫിക്കേഷൻ ഇറക്കി ആ നോട്ടിഫിക്കേഷൻ പറയുന്ന ഡേറ്റ് തുടങ്ങി മാത്രം മതി ഇത്. അപ്പൊ അതുവരെ ഫോറൻസിക് എവിഡൻസ് കളക്ട് ചെയ്യണ്ടേ? Then see, if this facility is not in our state, then what should we do? We should borrow it from the other state. The proviso, provided that where forensic facility is not available in respect of any such offence, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. So that is also there. Now we come to section 179. See, 179.1 is corresponding to section 160 subsection 1 of the code. 161. It deals with a police officer requiring the attendance of a person in the police station. A person who is acquainted with the facts and circumstances of a case. The main provision, no change with regard to, no change at all, main provision, as in section 160, subsection 1. But then comes the proviso. Provided that no male person under the age of 15 years, അത് നേരത്തെയും കോഡിലുള്ളതാണ്, then or above the age of 60 years. In the code it is 65 years. Or a woman, that is also in the code, or a mentally or physically disabled person, that is also in the code. Then that is the next thing is an addition, or a person with acute illness shall be required. No such a person shall be required to attend any place other than the place in which such a person resides. So, suppose a woman is an accused in a case, she is also a person acquainted with the facts and circumstances of the case. whether the police officer can require her attendance in the police station and accused, woman accused. Provision says otherwise. Any person acquainted with the facts and circumstances of the case. 160 one a corresponding provision. 179 1. Though in the margin it is stated that witness, it is witness. The main provision doesn't say so. Then anyway, it is a debatable point. In Nandini Saraswati's case, the Supreme Court held that they know. Woman accuser Petila. No. Then, however, later in a particular decision, it was held that this provision is not applicable to a woman accused. It is applicable only to witnesses. That is AIR 2004 Supreme Court 2282. AIR 2004 Supreme Court 2282. Now section 183. 183 corresponds to section 164 of the code. Recording of confessions and statements. 183.1, section 183.1, there is a slight change. Earlier, it was provided that any metropolitan magistrate now goes, or judicial magistrate can record the statement. Now, what is provided? Any magistrate of the district in which the information about the commission of any offence has been registered may, whether or not he has jurisdiction in the case, record. Suppose a crime is registered in a particular district, any magistrate in that district can record the confession or the statement. So, does it include executive magistrate? Any magistrate is used. Does it include executive magistrate? Why? Huh? This statutory provided now. Anyway, so. You may look into section 3.1. Of the BNS or under the code. കോഡിലത് പറഞ്ഞെങ്കിലും വീണ്ടും പ്രൊവൈഡ് ചെയ്തു. പക്ഷെ ഇവിടെ പറയുന്നില്ല. ഇവിടെ എല്ലായിടും ഒഴിവാക്കി. ജുഡീഷ്യൽ എന്നുള്ള വേർഡ് മിക്ക സ്ഥലങ്ങളിലും ഒഴിവാക്കിയിട്ടുണ്ട്. വൈ? In view of section 3.1, I think. Section 3.1 says, when the expression magistrate is used without any qualification, it means a judicial magistrate of the first class or a judicial magistrate of the second class. See, you read it with section 3.1. അതല്ലേ പറഞ്ഞേ, കോഡിലെ എവിടെയെങ്കിലും മജിസ്ട്രേറ്റ് എന്ന് മാത്രം ഒരു ക്വാളിഫിക്കേഷൻ ഇല്ലാണ്ട് പറഞ്ഞിട്ടുണ്ടെങ്കിൽ സെഷൻ 3(1) എന്താ പറയുന്നത്? But the importance is not like that. The change is there. Any magistrate in the district where the crime is registered. See, suppose it is a 0 FIR then. 0 FIR. 0 FIR is registered in a police station which has got no jurisdiction over the area. Suppose regarding an incident in Kerala, on the basis of 0 FIR, on the basis of information given to a police station at New Delhi, a crime is registered in a police station at New Delhi. So, as per this provision, any magistrate in the district in the district in New Delhi where that can record where the crime was registered can record the statement. This is also something to be interpreted. Now we come to section 183, subsection 6. That is recording the statements of victims of rape. Subsection 6. Now the first proviso to that provision. First proviso. Provided that such a statement shall, as far as practicable, be recorded by a woman magistrate. In our state, there may not be any problem. Almost 70% of the magistrates are lady officers. Then, a woman magistrate, and in her absence, by a male magistrate, then there is a condition. In the presence of a woman. If it is recorded by a male magistrate, it shall be in the presence of a woman. See, this is applicable only to victims of, when statement of victims of rape is is recorded. Now, the next proviso, second proviso, that is also a new one. Provided further the new provision, further that in cases relating to the offences punishable with imprisonment for 10 years or more, or with imprisonment for life, or with death, the magistrate shall record the statement of the witness brought before him by the police officer. Magistrate cannot refuse in such a cases. Now we come to section 184. 184 subsection 6. Medical examination of victims of rape. Subsection 6 says the registered medical practitioner shall, earlier in the code it was without delay, forward the report to the investigating officer. Now it is provided that within a period of 7 days, the report shall be forwarded to the investigating officer. Suppose there is a provision I think in the POXO Act that this medical examination should be done only by, in case of women, girl child, can only be by a woman doctor. Suppose it is being done, medical examination is being done by a male doctor. Can the accused take advantage of it? The accused cannot take advantage. The accused cannot take advantage. Because it is nothing to be concerned with the accused. If at all any grievance, it should be grievance should be by the victim. And suppose it is see 184 1 with the consent of such a woman or of a person competent to give such a consent on her behalf, this medical examination shall be done. Suppose in a particular case, when a child victim is examined, the written consent of the mother is not obtained. Can the accuser take advantage of it? No. That is what the High Court held recently in 2024 KER 17309. 2024 KER 17309. Now, section 185.1. Search corresponding provision is section 165.1 of the code. There is a slight change there. Before conducting search, the police officer has to record the grounds of belief. In writing, record in writing the grounds of belief for conducting the search. That is in the code also, 165.1. Now, in 185.1, it is added that the grounds of such a relief shall be recorded in the case diary. The case diary should reflect them. No. Under section 185.1. This is something which the defense lawyers can make use of. See, this is a very important pre-requirement of conducting a search, according to grounds of belief. So, if a police officer states, I had the grounds of belief and I had recorded, but suppose the case diary doesn't reflect it, specifically now provides. Then section 185(2), there also proviso. Search conducted under this section shall be recorded through audio, video, electronic means, preferably by mobile phone. That we had already seen in when we discussed section 105, I think. Then section 185(5). The record of this search shall be forwarded to the nearest magistrate empowered to take cognizance forthwith. That is in the code. Now something is added there, forthwith, comma, but not later than 48 hours. Not later than 48 hours. That is something new. Now we come to the most criticized provision in the BRSS. That is a remand of an accused, custody. Section 187(2). Corresponding provision is section 167(2). It is easy to remember. 167(2), 187(2). Before taking the changes, before taking you through the changes, I will give you some background. See, in interpreting the provisions contained in section 167(2) of the CRPC, the Supreme Court in Anupam J. Kulkarni's case, that is AIR 1992, Supreme Court 1768, AIR 1992, Supreme Court 1768, had held that AIR 1992, Supreme Court 1768. That is no more important now. Had held that police custody can be given, of an accused can be given, only during the initial 15 days. After the expiry of the first 15 days, no police custody of a person. And the total period shall also be 15 days. Total period. It was held by a 2-judge bench. Then, the decision in Anupam J. Kulkarni was doubted by the Supreme Court in another case, that is CBI versus Vikas Mishra, AIR 2023, Supreme Court 1808. AIR 2023, Supreme Court 1808. There, the Supreme Court raised some important questions, pertinent questions, doubting Anupam J. Kulkarni. Suppose when a person is arrested and produced before a magistrate, and on application by the police, when he is about to be remanded to police custody, or after the magistrate passes the order, but before he is actually given to police custody, he pretends some illness. Then what happens? The magistrate has to admit him in the hospital. magistrate may not normally may not take any risk under judicial custody. By the time he gets out of the hospital, the initial 15 days will be over. Then no more, he need not be given to the police custody, he cannot be given to the police custody. It may also happen that he really suffers for example, suffers some illness, for example, heart attack. And he may be admitted in the hospital. He comes out from there after a surgery. By that time, the initial period of 15 days will be over. Then what is the option before the police? If he is still in judicial custody, go to the jail and question him with the permission of the court consent. But that may not be effective as custodial interrogation. Then take another situation. Suppose in a particular case, the magistrate refuses police custody. There are genuine reasons for the police to ask police custody, but the magistrate rejected the application. Naturally, the investigating officer or the state may take up the matter before the superior court, maybe the High Court. By the time the High Court decides the matter, and if the High Court finds that this is a fit case in which the magistrate ought to have granted police custody, then what is the option? Nothing can be then done there also. This was the situation. These questions were asked by the Supreme Court in AIR 2023, Supreme Court 1808. In that particular case, the Supreme Court cancelled the bail granted to the accused by the High Court, I think, and remanded him to police custody for the rest of the period for which he was required. Then this, mind you, this was a two-judge bench, AIR 2023 Supreme Court 1808. Then came the case of Senthil Balaji, the Tamil Nadu minister. That is 2023 for KLT 814. 2023 for KLT 814, Supreme Court. There also the two-judge bench doubted the earlier two-judge bench decision of Anupam J. Kulkarni. But the Supreme Court referred the question of law to a larger bench. Question of law to a larger bench. But the Supreme Court decided the case on the facts of that particular case, found that this period of 15 days should begin only when the accused is given in actual custody of the police. When the accused is given to actual custody with the police, then only the period will begin. In that manner, a practical approach was made and the case was decided on facts. The larger issue was referred to a larger bench and it is pending before the Supreme Court for consideration. Now we come to section 187.2 and look at the changes. Why I said these background facts, you will understand when I read this. the section 187(2), the magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration, that is added there, after taking into consideration whether such a person has not been released on bail or his bail has been cancelled. That is an addition. I will come to that later, that change. Authorize from time to time the detention of the accused in such custody. In such custody, it may be police custody or judicial custody, as such magistrate thinks fit, for a term not exceeding 15 days in the whole, or in parts, that is an addition, but that is not important because earlier also it could have been done. So, for example, first 7 days police custody, then 3 days judicial custody again. If it is within the initial period of 15 days, again he can be given to police custody. No problem. Or in parts, then at any time during the initial 40 days or 60 days, out of the detention period of 60 days or 90 days, as the case may be. You know, in some cases, in order to avoid the accused getting default bail, charge sheet has to be filed within 60 days. In other cases, 90 days, grave crimes. So, at any time during the initial 40 days or 60 days out of the 60 or 90 days, the police can seek custody of the accused. The magistrate can authorize his detention. That is the important change. There is no problem. The problem, legal problem is for the accused. The question is not that, can then this period, total period, exceed 15 days? ആകെ ഒരാളെ പോലീസ് കസ്റ്റഡി കൊടുക്കാവുന്ന പീരീഡ് 15 ദിവസത്തിൽ കൂടാൻ പറ്റുമോ? ഫോർ എക്സാമ്പിൾ 40 ദിവസം വരെയോ 60 ദിവസം വരെയോ പോകാൻ പറ്റുമോ? In order to understand that, you have to read the next provision also. That is corresponding to clause A of the first proviso to section 167(2), which dealt with extension of remand. Earlier, extension of remand is dealt with under clause A of the first proviso to section 167(2). Now the corresponding provision is section 187(3). 187(3) says what? The magistrate may authorize the detention of the accused person under the code. Thereafter, there was an expression, otherwise than in police custody. That expression was there in the code. Now in 187(3), that expression is omitted. It is interpreting this otherwise than in police custody that in Anupam J. Kulkarni, the Supreme Court held that it can never exceed beyond the initial 15 days. ഈ എക്സ്റ്റൻഷൻ വരുന്നത് ആദ്യത്തെ 15 ദിവസം മാത്രമേ പറ്റുള്ളൂ എന്ന് പറഞ്ഞത് ഈ അതർവൈസ് ദാൻ ഇൻ പോലീസ് കസ്റ്റഡി എന്നുള്ള എക്സ്പ്രഷൻ കോഡിൽ ഉണ്ടായിരുന്നുകൊണ്ടാണ്. അതായത് എക്സ്റ്റെൻഡ് ചെയ്യാവുന്നത് അതർവൈസ് ദാൻ ഇൻ പോലീസ് കസ്റ്റഡി, ദാറ്റ് മീൻസ് ജുഡീഷ്യൽ കസ്റ്റഡി. that is omitted. Beyond the period of 15 days, if he is satisfied that adequate grounds exists for doing so, but no magistrate shall authorize the detention of the accused person in custody, so and so. So simply reading a plain reading of section 187.2 and 187.3 would support the criticism leveled against these provisions so that a person can be given to a total period of 40 days or 60 days to police custody. Because the expression otherwise than in police custody now omitted. That is on a plain reading. But jurists would now interpret this provision in such a manner that if 187.2 says 187 in 187.2 it is specifically stated the first 15 days, not first, the whole period 15 days. Therefore, it is stated that even now, some jurists have explained this that in such a manner that even now, on a conjoined reading of sections 187.2 and 187.3, the total period can never exceed 15 days. Though it can be given in broken periods during the initial 40 or 60 days. And the Home Minister has also stated in the debate during the debate on the bill in the Parliament that we never intend a police custody of more than a total period of 15 days. And in a press meet also outside after this law it came into force. But actually reading the provisions it will not reflect, especially when the other expression is omitted, otherwise than police custody. Anyway, that may, I think we will get decisions on this point also very soon, because it will come before the court for interpretation. Definitely. Now we come to the other change. Now, at any time before the initial 40 expiry of the initial 40 days or 60 days, a person can be sought in police custody. The police has got the right. Does that mean that he cannot be granted bail till the expiry of the initial 40 days or 60 days? Bail can be granted provided he is otherwise eligible to get bail. Merely for this reason that the police may seek again custody of the accused during the initial 40 days or 60 days will not prevent the court from granting bail. Where it is provided under the third proviso to section 480 subsection 1 relating to granting of bail by magistrates in non-bailable offences. 480 subsection 1 the third proviso. Merely for this reason, bail cannot be refused if he is otherwise entitled to. without looking into this provision, ignoring this provision, third proviso to section 481, many of the even experts in the legal field say that no bail could be granted. That is not correct. Bail can be granted provided if he is otherwise entitled. It specifically stated provided. Now the problem is not there. Bail can be granted under this proviso to third proviso to section 480 subsection 1. Suppose in a case bail is granted. After granting bail, before the expiry of the 40 days or 60 days, police again seeks custody. They have got a right. What the magistrate is expected to do? Can he cancel the bail and remand the police custody? Suppose the bail is granted by a superior court, court of session or the high court, and no specific authorization is made enabling the magistrate to cancel the bail. What happens? Here comes the importance of the expression change. എന്താണ്? After taking into consideration whether such a person has not been released on bail or his bail has been cancelled, the magistrate, before authorizing detention, has to take into consideration whether bail has been granted or whether such bail has been cancelled. There also there is some vagueness. The provision only says the magistrate shall consider whether he has been released on bail or whether such bail has been cancelled. Magistrate consider is who? Magistrate consider. Then what? The question is not there. Has he got the power to cancel the bail? And it is a settled proposition of law that once a person is released on bail, unless the bail is cancelled, he cannot be remanded to either police custody or judicial custody. There are decisions of the Supreme Court. So what the magistrate is expected to do? This is an area of confusion, somewhat. This also requires interpretation by the constitutional courts. Till then, the magistrates will interpret in their own way and they will do. Aggrieved parties can approach the High Court or the Superior Court, whichever court. Then, at least if it is before the High Court, a decision will come. എങ്ങനെയുള്ള സിറ്റുവേഷനിലാണ് പറയുന്നത്? Strictly speaking, the police has to first approach the court which granted the bail for cancellation on this ground. Then thereafter, they can come to the magistrate court for custody. If it is before the magistrate can also consider. Because section 480, subsection 5, I think, enables the magistrate to cancel the bail if it is granted by the magistrate. Bail is granted by the magistrate, not by the superior court. Now we come to default bail. Again, section 187.3. 187.3. What is the position under the code in case of offences punishable with imprisonment for a period of 10 years? See, in section 167.2, proviso A, clause 1 says 90 days where the investigation relates to an offence punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years. So, under the code, interpreting this expression, imprisonment for a term of not less than 10 years, in Rakesh Kumar Paul, the Supreme Court held that only where the offence is punishable with a minimum sentence of 10 years. That means, suppose the court convicts a person, then the minimum sentence that court should impose is 10 years. അത് കുറഞ്ഞ് കൊടുക്കാൻ പറ്റില്ല. അങ്ങനെയുള്ള കേസുകളിൽ മാത്രമേ only in such types of cases the period of 90 days will apply. That was held so interpreting the expression imprisonment for a term of not less than 10 years. That is in Rakesh Kumar Paul, AIR 2017 Supreme Court 3948. AIR 2017 Supreme Court 3948. Now, what is the stated? See, what is stated under section 187.3 or Roman letter 1? അതിന്റെ എൻഡിൽ നോക്കുക, imprisonment for a period of 10 years or more. So the other expression goes, that imprisonment for a term of not less than 10 years goes, then comes the expression imprisonment for a term of 10 years or more. So what is the effect? Rakesh Kumar Paul goes to that extent. And the period will be in all cases where imprisonment is provided as a punishment for a term of 10 years or more, it will be 90 days. That is a change with regard to default bail. Then one more thing under that provision. See, in Gautam Navalkar's case, the Supreme Court held that the magistrates are empowered to authorize the detention of a person in house arrest. Gautam Navalkar, 2021, SCC online, Supreme Court 382. 2021, SCC online, Supreme Court 382. Now, please take the proviso to second proviso to section 187.5. 187.5 explanation 1, explanation 2, പിന്നെ ഒരു പ്രൊവൈസോ, അത് കഴിഞ്ഞിട്ടൊരു പ്രൊവൈസോ, ആ സെക്കൻഡ് പ്രൊവൈസോ എന്താണ്? Provided further that no person shall be detained otherwise than in police station under police custody or in prison under judicial custody or a place declared as a prison that amounts to judicial custody by the central government or state government. So this Gautam Navalga's case also goes to that extent. The provision starts with no person shall be detained. So it is a mandatory thing. Then there is an exception to this. That exception means if you want to know, read the proviso before that. The first proviso. The first proviso.
So it's the time for tea break. Let's take the break of 15 minutes and reassemble thereafter.
Now, welcome back. The next provision is section 190, subsection 1. 191. There is no change in the main provision, but the proviso is, there is a proviso there, that is a new provision. Provided that if the accused is not in custody, the police officer shall take security from such person for his appearance before the magistrate, and the magistrate to whom such a report is forwarded shall not refuse to accept the same on the ground that the accused is not taken in custody. See, there is a practice in some states that when, suppose during the investigation, an accused is not arrested, and if charge sheet is filed, the accused has to be arrested and produced along with the charge sheet. Then only the magistrate will accept the charge sheet. Now, it is by adding this proviso that practice would be stopped. Now, section 193. എനിക്ക് പറ്റില്ല 6 മണി വരെ പോവാൻ എനിക്ക് പറ്റില്ല പറഞ്ഞ Section 193, subsection 3. That is forwarding the charge sheet, or the charge sheet is that not word is not used, but the report, police report to the court. The important change is, see that Roman letter 1, as soon as the first provision is, as soon as 193.3, as soon as the investigation is completed, the officer in charge of the police station shall forward. Then there is an addition, including through electronic communication. So, e-filing of charge sheet is provided, enabled to a magistrate employed to take cognizance of the offence on a police report. That is one thing. Then coming further, you can see A, B, C, etc. Take clause I. Clause I. A, B, C, I. Last I. The sequence of custody in case of electronic device. If an electronic device has been taken into custody, the sequence of custody shall be mentioned along the charge sheet. And what is this sequence of custody? Suppose some device, electronic device, is taken into custody, it may be handed over by that person who has taken into custody, officer, to some other officer, for example the SHO, thereafter the investigating officer. ഇങ്ങനെ കൈമറിഞ്ഞ് പോയേക്കാം ചിലപ്പോൾ ഇൻവെസ്റ്റിഗേഷൻ. അല്ലെങ്കിൽ a new investigating officer comes, then each and every time this shall be documented. ആർക്ക് കൊടുത്തു, ടൈം, ഡേറ്റ്, everything should be recorded. If you want to know more about this, here the expression used is sequence of custody. But if you want to know more about that, you may read the decision reported in AIR 2023 Supreme Court 2938. What is the chain of custody? What is chain of custody? AIR 2023, Supreme Court 2938. Now, all of you may aware the recent decision of the High Court of Kerala with regard to custody of digital evidence during investigation as well as in the court, which contains sexually explicit materials. That is 2024 1 KSC 69. 2024 1 KSC 69. Then see that provision 193.3 starts with, as soon as the investigation is completed, the officer in charge of the police station shall forward a police report. So whether the officer in charge of the police station will include the head of a special investigation team, whether the head of a special investigation team, the expression used here is the officer in charge of the police station shall forward. If you want to know, you may read this decision. That is 2024 2 KC 200. 2024 2 KSC 200. Filing of charge sheet by the head of a special investigation unit or team. 2024 2 KSC 200. Now, the next provision is, what is the provision under the code regarding further investigation? Section 173.8. Now the corresponding provision is section 193.9. 193.9. There is no change in the main provision. There is no change in the main provision. But a proviso is added, which states provided that further investigation during the trial may be conducted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. Whether under the code, when the police conducts investigation under section 173.8, further investigation, is any permission from the court required? No. What is required is only an intimation to the court. That is also a matter of courtesy, that so that the court can arrange or regulate the trial. Then see this provision now provides how, if such an investigation is being conducted by, further investigation is being conducted by the police after the commencement of trial of the case, that is during the trial. After the commencement of trial of the case, the investigating officer shall obtain permission. Permission from which court? The trial court. The trial court. And such investigation has to be completed within a period of 90 days. Suppose that investigation cannot be completed within a period of 90 days, It can be extended with the permission of the trial court. Whether in any case the trial court can deny permission. Oh. The trial court can deny permission provided it is satisfied that the further investigation is proposed to be conducted by the police for giving undue advantage to any party, for example, to help the accused. Without sufficient ground. You may read 2023 3 KSC 588. 2023 3 KSC 588. Now, what about the extension? When in a particular case, the further investigation cannot be completed within a period of 90 days, the police seeks extension of time. Can the court deny such extension? Can the court say that no, the trial will get delayed? The trial will get delayed if further time is granted. Generally, it cannot be denied extension because the court has granted permission after considering the fact that such further investigation is necessary for the interest of justice, advancement of the cause of justice. Then the court has to see that that is completed. On the ground that the trial would be delayed, the court cannot deny permission for extension. AR 2024, AR 2004 Supreme Court 2078. AR 2004 Supreme Court 2078. Again, AR 2009 Supreme Court 2308. AR 2009 Supreme Court 2308. Now, section 202. Section 202, subsection 1. Any offense which includes cheating may, if the deception is practiced by means of then something is added by means of electronic communications or letters or telecommunication, etc. Local jurisdiction that is provided there. Now, in case of electronic communications also, if an offense is, if deception is practiced by means of electronic communication. Now, section 208. Corresponding provision is section 188. The offense is committed abroad by a citizen of India or by a person not being such a citizen on any ship or aircraft registered in India. He may be dealt with in respect of such offense as if it had been committed at any place within India at which he may be found. Now something is added. Or where the offense is registered in India. Suppose in such a case, if the offense is registered in India at a particular place, the accused can be dealt with even if the offense was committed abroad. as if he had committed the offense at that place in India. Then now section 210, corresponding provision is section 190, 190, taking cognizance. As you know, there are three modes for taking cognizance. One is upon a complaint, the second is police report, the third is upon other information or upon his own knowledge of the magistrate. Then here, with regard to complaint, under clause A, section 210(1) clause A, this is added upon receiving a complaint of acts, that is under the code also, then including any complaint filed by a person authorized under any special law. You know, in some special statutes, there will be a provision like this: no court shall take cognizance except upon a complaint filed by such and such an officer. When it is provided, when a complaint is filed by such officer, it shall be deemed to be a complaint under section, deemed it is a complaint under section 210(1). Then regarding police report, upon a police report, then it is added there, submitted in any mode, including electronic mode of such facts. So, e-filing of charge sheet is done. The magistrate can take cognizance on that. There is no physical charge sheet. No physical charge sheet is necessary. This will have some implication, significance, when we reckon or calculate the period of 60 days or 90 days for the purpose of default bail, to know whether charge sheet is filed or not. Here, e-filing of charge sheet, cognizance can be taken when. So, once e-filing is done, that is sufficient. I will give you an example. Suppose the period of 60 days or 90 days ends on a second Saturday. Normally, in order to avoid default bail, in order to avoid the accused getting default bail, the police has to file the charge sheet before the magistrate at his residence, if they want. It is not sufficient that the police files the charge sheet on the next working day. No. If the police files the charge sheet on the next working day, he will be entitled to get default bail. Now they can very well avoid the accused getting default bail by filing the charge sheet through e-communication on a holiday. Now, section 215. See, it is a bar to take cognizance of some offences. Bar. No court shall take cognizance of such and such offences, except upon a complaint in writing by the public servant concerned. That is in the code also. Now here what is added is, and the last portion of that clause A, clause A യുടെ ഏറ്റവും അവസാനത്തെ ഭാഗം, or of some other public servant who is authorized by the concerned public servant so to do. So the public servant concerned can authorize another public servant to file a complaint. Now section 215(2). Withdrawal of such a complaint that can also be made on the basis of an application filed by the public servant who has been authorized by the public servant concerned. Another public servant who has been authorized. Now, what is the provision under the code regarding sanction for prosecution? 197 subsection 1. Now, the corresponding provision is section 218. 18(1). There is no change in the main provision, substantive change, but a proviso is added as second proviso. നോക്കുക section 218. Provided further that such government shall take a decision within a period of 120 days from the date of the receipt of the request for sanction, and in case it fails to do so, the sanction shall be deemed to have been accorded by such government. Normally, when a request for sanction for prosecution against a public servant is made, especially by a private citizen, what happens? The government will not take any decision. The government will not grant the sanction. The government will not refuse the sanction also. Now, such a lethargy on the part of the government cannot be there anymore. Because once a request for sanction is received, and if no decision is taken by the government within 120 days from the date of receipt of that request, the sanction shall be deemed to have been granted. Then after the expiry of the period of 120 days, the bar under the main provision regarding taking cognizance disappears. This is a provision which is detrimental to the public servants. There are many provisions given added benefits or added protection to them. So at least one provision is there which takes away something. Because if it is a written order of sanction, it will be challenged on many grounds. Non-application of might. Then the competent authority did not consider the materials. All these types of grounds will be taken to challenge the sanction for prosecution. Now, when in case of a deemed sanction, nothing is there.
Most of you may be happy on this provision.
No. Because they loses the opportunity to of more litigation. Because if that provision is there, those things could have been challenged before the court, and the trial could have been protracted.
അത് ശരിയാണ് പക്ഷേ most of the time there may not be any sanction obtained from the government.
Only private citizens.
These advocates, when filing cases against police, most of the
Very
occasions
rare.
it causes until that you may not get any sanction. Now the deemed sanction concept is there. It may help to a certain extent, provided with the rider clauses at the time of filing private complaints.
സർ നല്ലൊരു പ്രാക്ടീസ് ലോയർ പോലീസൊക്കെ പറഞ്ഞു ആ പരിപാടി നിർത്തി പിന്നെ ഓഫീസ് ഷീറ്റ് വിട്ടു.
Especially you are from the Chavakadu, that is because I have got some personal knowledge about. That's why I am saying, which I had to deal with once. Now, the see, this sanction is required. Whether sanction is required against all public servants, sanction for prosecution. Not that. The category, that is emphasis. I am giving emphasis.
Irrespective of that designation, whether required for all public servants.
See, debating 197 1 218 എന്താ പറയുന്നത്, when any person who is or was a judge or a magistrate or a public servant not removed from his office save by or with the sanction of the government is accused. There can be other public servants. No sanction will be necessary. At least under the CRPC or the BNSS. Maybe under the special statutes it may be required. Now, only in cases whether such a public servant is removable from office by or save with the government, this is attracted. Now a question may arise, sub-inspector, whether he is such a person, whether he is removable by the government only, removed from service, or whether any sanction is required. No. However, sanction is required. Why? See subsection 2. No court shall take cognizance of any offence unless it have been committed by any member of the armed forces of the Union while acting or purporting to act in the discharge of his official duty, except with the previous sanction of the central government. Now, read the further provision, subsection 3. The state government may, by notification, direct that the provisions of subsection 2 shall apply to such a class or category of the members of the forces charged with the maintenance of public order, as may be specified therein, wherever they may be serving. Then, the central government, the expression central government shall be deemed to be state government. That is there. So the government have issued a notification as far as our state is concerned, and therefore sanction will be necessary against a sub-inspector also. You may read the recent decision 2024 KSC online 483. 2024 KSC online 483. Then there are slight changes under that chapter regarding bar to take cognizance. Only slight changes. I am skipping those provisions. Then the important change, next provision, section 223. The corresponding provision is section 200 of the code. ഈ ഒന്നാം തീയതിക്ക് ശേഷം 1/7/2024 ശേഷം 138 ഒഫൻസിന് NI ആക്ട് ഒഫൻസിന് പ്രൈവറ്റ് കംപ്ലൈന്റ് ഫയൽ ചെയ്ത ആരെങ്കിലും ഉണ്ടോ? മീറ്റ് ചെയ്യാൻ ഫയൽ ചെയ്ത ആരെങ്കിലും ഉണ്ടോ എന്നാണ് ചോദിച്ചത്. ആരുമില്ല.
20 ദിവസമായിട്ടോ?
ഓ, അതിനു വേണ്ടിയിട്ടാണ് വെയിറ്റ് ചെയ്യുന്നത്. ഫയൽ ചെയ്തിട്ടുണ്ടോ? വാട്ട് ഡിഡ് ദി മജിസ്ട്രേറ്റ് ഡു? That may be. What did the magistrate do?
ഇല്ല, ഇരുന്നിട്ട് പറഞ്ഞാൽ മതി.
Court fee
അല്ല, കോർട്ട് ഫീ കൊടുക്കുന്നത് ഫയലിങ്ങിനെ ബാധിച്ചിട്ടുണ്ട്.
ചെന്നൈയിലൊക്കെ പോയി ഫയൽ ചെയ്യുന്നുണ്ട്.
ആണോ?
കമ്പനികളൊക്കെ ചെന്നൈ, ഹൈദരാബാദൊക്കെ പോകും.
ഓ, അപ്പൊ സത്യത്തിൽ ബാക്ക് ഫയർ ചെയ്യുവാന്ന് ചെയ്യും.
We can read section 223(1).
ഇതിലെ കാര്യം കൊണ്ടാണ് ചോദിച്ചത്. വേറെ ആരും ഫയൽ ചെയ്തില്ലല്ലോ. ബിക്കോസ് ഓഫ് ദിസ് കോർട്ട് ഫീ ആസ്പെക്ട്.
Not because of court fee action. Not because. അതെന്നെ ചോദിച്ചേ. അത് നിങ്ങക്ക് ഡയറക്റ്റ് നോളജ് അല്ലല്ലോ, പറഞ്ഞു കേട്ട വിവരമല്ലേ. I have already stated with regard to an act done before 1/7/2024 and the proceedings initiated after 1/7 in respect of such act. While we discussed section 531, how can it be? Whether any inquiry was pending, whether any trial was pending.
You initiated the action after 1/7. On or after 1/7, it's mandatory.
Now, a magistrate, section 223(1), having jurisdiction, that is something I added there. Earlier under the code it was not there. Then the main provision say. Now we come to the proviso. Provided that, first proviso, no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. So even before taking cognizance, the magistrate cannot record the statement of the complainant. No, that will amount to taking cognizance. Or even if he decides, that will amount to taking cognizance. Even before that, what shall be done? The accuser shall be given an opportunity of being heard. അപ്പോൾ അങ്ങനെ ചെയ്യണമെന്നുണ്ടെങ്കിൽ if the accuser has to be given an opportunity of being heard, what the court has to do? Issue a notice. Then, see, it is only on a private complaint, not on a police report. Only when cognizance is taken on a complaint. Then, suppose the accused in that case is a public servant. Then there are additional protections given to him. Section 223(2). Section 223(2). A magistrate shall not take cognizance. Magistrate shall not take cognizance on a complaint against a public servant for any offence alleged to have been committed in course of the discharge of his official functions or duties unless such a public servant is given an opportunity to make assertions as to the situation that led to the incidents so alleged and a report containing facts and circumstances of the incident from the officer superior to such a public servant is received. We had earlier seen the same thing. There also. So, in effect, if a complaint is filed against a public servant, in order to order investigation, these requirements are necessary. If the magistrate wants to take cognizance, then also these requirements are necessary. രണ്ടും ചെയ്യാൻ പറ്റില്ല ഈ റിക്വയർമെന്റ്സ് കംപ്ലൈ ആകും. ഇനി ഈ നേരത്തെ നമ്മളെ 223(1) പ്രൊവൈസോ ഉണ്ടല്ലോ, നോ അക്യൂസ് നോ court shall take cognizance of an offence except giving an opportunity of hearing to the accused. Suppose he appears before the court pursuant to a notice issued by the court. What can he say? He can say anything. Whether the court is supposed to hear whatever he says. Yes, with regard to the complaint, whether the court is supposed to hear him whatever he says.
What of his defense against taking cognizance?
He can only say, in my view, he can only say, for example, this is barred by limitation. This is liable to be rejected. Then he can say, technical objections can be raised. Then he can say, the allegations in the complaint do not reveal any offense at all. It is liable to be rejected. Apart from that, I don't know whether any other contention can be put forward then. How can he raise a contention that, no, I have not committed this offense? He can say, of course. What value the court should give to his words? That is also scope of the hearing. That is also something to be now explained by the or interpreted by the constitutional courts. Now, section 227. 227, subsection 1. There is no change in the main provision. It is corresponding to section 204 of the code. But the proviso, that is something new, proviso, provided that the summons or warrants may also be issued through electronic mode. Warrants can also be issued. See, we have already seen a change is made or something is added regarding the form of summons, enabling e-communication. But there is no such a thing added to the form of warrant. The provision says that it has to be signed by the presiding officer. Then how can it be sent through or forwarded to e-communication? So also some clarification or explanation is required. And in case, suppose it is being sent, it can be sent. Assume that it can be sent. There is a way. What the police officer getting this through some electronic device, this warrant is expected to do. That is also a question. Is it sufficient that suppose it is in his mobile phone? When a person is to be arrested, he wants to see the warrant. It is a different thing. Nobody will dare to ask a police officer where is the warrant. That is a different thing. But he has got the right. Is there any warrant? And can he say this is the warrant? I don't know. The formality is now going to be there. Like when during our train journey, when the TTE comes, we show him the ticket in the mobile phone. E-tickets, like that. I think again the Ministry of Home Affairs might have issued some guidelines or SOP, standard operating procedure, in this regard also. Maybe.
And there some countries there is a concept of digital arrest also. nobody ever thought of the fact that these payment system introduced, it will become that much ubiquitous in all of a sudden. But it happened. We can expect that such things will happen in our country soon also. That suppose everything is connected with bank, other facilities, and all of a sudden it's gets freezed. What you will do? And even if you have to travel on bus, your system is connected with the payment, and you are debarred from using that. How you will make use of the system? Such things we have to foresee such a situation also.
Anyway, I am not criticizing these provisions, but it is surely there will be teething problems. When any new provision is implemented, there will be teething problems. Ways I have to find out, resolve those problems. That is the only thing. Then, section 230. Supply of copies of records. Corresponding provision, section 207. It says, the magistrate shall, without delay, and in no case beyond 14 days from the date of production or appearance of the accused, that is added there, furnish to the accused copies of records. Then one more thing is added there, furnish to the accused and the victim if represented by counsel. Victim, that is also added. Only condition is that you should be represented by a counsel. Free of cost, copies of the 11 records. Now the second proviso to that provision, second proviso 230. If the documents are voluminous, instead of furnishing the accused and the victim if represented by an advocate with a copy, the court may furnish the copies through electronic means. Then also copies can be furnished through electronic means to the accused and victim if the documents are voluminous. Then the third proviso, അങ്ങനെ furnish ചെയ്താലോ, what is the consequence? Supply of documents in electronic form shall be considered as duly furnished. The accused cannot say that, no, I want it in physical form. No. Because the stated supply of documents in electronic form shall be considered as duly furnished. Here you may, I don't know how many persons are aware of the recent amendment to the Criminal Rules of Practice. Rule 19, Sub-Rule 4. Rule 19, Sub-Rule 4. Along with the charge sheet and supply the copies of records when it is furnished to the accused, not only the documents, copies of the documents relied upon by the prosecution should be furnished, but a list containing documents, material objects, etc. not relied upon by the prosecution should also be furnished. It is not copies, but a list of such a documents not relied upon, list of material objects not relied upon. That should be furnished to the accused. That provision is introduced in the incorporated in the rules of practice in accordance with the direction of the Supreme Court in one case. And there are decisions also. A recent decision of the High Court of Kerala, 2024 KSC Online 582. 2024 KSC Online 582. Then two decisions of the Supreme Court, 2023 2 SCC 353. 2023 2 SCC 353. Then 2022 KSC 7177 Supreme Court. 2022 KSC 7177 Supreme Court. Suppose a CD or a pen drive contains sexually explicit materials or obscene materials or pornographic materials, whether the accused is entitled to get a copy, and what else he can do? He should be permitted to inspect, inspect and see the contents in the presence of his lawyer and in the presence of the court or an authorized officer of the court, and also one more person. If necessary, in the presence of an expert, if wanted by the accused, in the presence of an expert. Where is it stated? Oh. AR 2020, Supreme Court, page number 1. AR 2020, Supreme Court, page number 1. Now, section 232. The corresponding provision is section 209, committal proceedings. There is no change in the main provision. But the first proviso to section 232 is a new provision. What does it say? The proceedings under this section shall be completed within a period of 90 days from the date of taking cognizance, and such period may be extended by the magistrate for a period not exceeding 180 days for reasons to be recorded in writing. So committal should be made within a period of 90 days from the date of taking cognizance. If not possible, for reasons to be recorded in writing, the magistrate can commit the case within a period of 180 days. Suppose the magistrate is not able to commit the case within a period of 180 days also, then what? No consequence provided. Then the next proviso, that is also a new provision. That is important, very important. Provided further that any application filed before the magistrate by the accused or the victim, or a person authorized by such a person, in a case triable by a court of session, shall be forwarded to the court of session with the committal of the case. So even an application is filed by a victim or an accused, it shall be forwarded to the court of session along with the committal of the case. This may create problems. Suppose when a bail application is rejected by a court of session or the High Court, liberty is granted to the accused to file application for bail after filing of the charge sheet, to approach the jurisdictional court, that is mentioned. Then such a person files an application for bail during the committal proceedings. What happens to that application for bail? If this proviso, second proviso, is strictly complied with,
bail application കൂടെ കെട്ടി സെഷൻസ് ജഡ്ജിക്ക്
it may reach the sessions court after 2 months.
എന്ത് ചെയ്യും? ഒരു ഉത്തരം പറ. തേർഡ് പാർട്ടി ക്ലെയിം പെറ്റീഷൻ എന്ന് വെച്ചാൽ ഇന്ററിം കസ്റ്റഡിയുടെ ആപ്ലിക്കേഷൻ ആണോ?
Let us first discuss this thing.
ഒരു മനുഷ്യന്റെ
This is important, more important.
അകത്ത് കിടക്കുന്ന റിലീസ് അല്ലേ?
Committed, especially trial by a sessions court.
ഇൻവെസ്റ്റിഗേഷനിൽ ബെയിൽ കൊടുത്തില്ല.
Suppose a bail application is filed.
Then just we are visualizing a situation where bail initially was not granted by the court with a rider that on filing final report you are free to approach the trial court or jurisdictional court.
Jurisdictional court. That means my
That with a rider with a condition that on filing final report you can approach the
you can
jurisdictional
again approach. You are at liberty to approach the jurisdictional magistrate.
whether this
But
provision
this second provision is not a restriction.
provided Saradin provided further that any application filed before the magistrate
Filed before the magistrate.
by the accused or victim
In a case trial by the court of session shall be forwarded to the court of session with the committal of the case. It implies that it is filed during the committal proceedings, because it is a proviso to the committal proceedings. Procedure provided there is committal proceedings. അതിനെയാണ് ഞാൻ ചോദിക്കുന്നത്. What is the way out?
അതിനെ നമ്മളൊക്കെ എങ്ങനെ തരണം ചെയ്യാം? അതിനി പറ്റില്ല. There are subsequent provisions also.
So this is a problem. This has to be interpreted by the constitutional courts. Anyway, my view is that the magistrate has to consider it, whether allow or disallow, because otherwise it will violate Article 21 of the Constitution of India.
Then constitutional provision will prevail over this provision. ഏതിലാ? Hello, though such a proviso is added, still considering the spirit of constitution and its principles, magistrate can consider whether the bail is to be granted or not. അതല്ലേ നമ്മുടെ എല്ലാ ലോയുടെയും മണ്ടയ്ക്കുള്ള ലോ.
Now, under the code, the suppose a person has committed offences of the same kind, more than one offence, within a period of 1 year. How many of such offences can be tried together, charged together? 3. Now you may take section 242, subsection 1. Subsection 1. You may only use the last word of that section. That is the only change. That is the only change. Now we will conduct the trial before a court of session tomorrow.
പോരെ ട്രയൽ നാളെ രാവിലെ തുടങ്ങിയാ പോരെ Any questions? Any doubts regarding the portions covered today? കാരണം നാളെ ഉച്ചയ്ക്ക് സമയം കിട്ടൂല to ask questions because the remaining portions and 2 other statutes we have to cover within a limited time available on tomorrow. Courts.
So now the only thing is that when we see that compartmenting theory, once trial is not started and one sessions case is pending before the assistant sessions, it has to go back because it is not an assistant sessions court as far as the new act is concerned. Once trial is started, then that has been started, we may say. But if trial is not started, it is merely pending there, then we will have to send back to the sessions court.
The word as Sir said on the morning session, the word used is pending. Not that trial started. Word used in present tense as is pending means as on the date when it is pending, the court is there because the person was appointed and the notification was issued and therefore the court is in existence.
See, we only discussed section 531, 2 clause A only. There are subsections 2 and 3 also, which says all orders, the appointments, etc., issued under the code.
Will
Saved,
survive.
are saved. Everything issued under the code, saved under subsections
2B,
2 and subsections 2, 3 and 4. 3.
B, C, and then 3.
B, C, and 3. We have already discussed an important thing, that is clause A of subsection 531. That is why
That is why we said don't say to the sub judges or assistant session judges that your post no longer exists and therefore you shall stop the proceedings.
A clarification, sir. Whether in 138 offences, the section 210 notice is mandatory or not?
Why you are holding an opinion that it is not mandatory?
Because in 138 offences are person specific, and without an accused, it cannot be proceed further.
There is one decision on that. Sir, not touch on that decision. That in 130 there is one decision which says that we are taking cognizance against an offender,
Yes.
not against an offense.
Yes.
That decision is there, but we cannot bring into act that decision into action? Because that was
Some High Court or the Supreme Court should say that, interpreting that provision, a complaint for an offence under section 138 will not come under the first provision to section 223(1) of the BNSS. Then, yeah,
ഒരു ഫൈനൽ ഒറ്റവാക്കി പറഞ്ഞാൽ എന്താണ് സാർ അതിന്റെ നോട്ടീസ് വേണം?
strictly.
considering the present context, notice has to go.
Unless and until some constitutional courts say otherwise.
Summary proceedings എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ ഇപ്പൊ summary trial there are changes, but previously what was the word used and what is happening in our state? Any court was conducting a summary trial in 138 proceedings?
See, this is a provision with regard to taking cognizance, section 223, on a complaint. A complaint for an offence under section 138 can be only in writing. No doubt. Section 142 of the NI Act. That also deals with taking cognizance on a complaint. There also the expression is used, notwithstanding anything contained in the CRBC. Whether that could be adopted here for the purpose of excluding this new provision, non-obstructive clause under section 142 of the NI Act, that is a question to be decided by the constitutional courts. We can only say our opinion. One way or other, we can say only our opinion. Unless some constitutional court says it. Strictly speaking, this applies.
Section 200 does not come within that. Then for
It will be well and good if some High Court or the Supreme Court also well and good. Ah, yes, yes. It is only on cognizance. Taking cognizance.
that is 223 is for taking cognizance. Forwarding, that is governed by other sections.
There also we have to see in the restrictions for forwarding.
Straight away, the
We had already discussed 175(3). And I have specifically emphasized, compared to section 156(3), the power of the magistrate is now circumscribed, limited, restricted, because there are prerequisites brought in.
Has to be called initially to provide him an opportunity before taking office. And again, if the court finds that cognizance is to be taken, he has to record again twice.
That is, we have to adopt a practical approach. If he is represented by a counsel, in my view, it will be necessary only to give notice regarding the posting date to the counsel. Otherwise, you will have to, the court will have to issue again summons. That is why I am saying.
And in 2021 KJC 6768, the Honorable Top Court held that the cognizance is taken of the offence and not the offender. അപ്പോൾ ഈ സാഹചര്യത്തിൽ ഇത് അത് റീസെന്റ് ആയിട്ടൊരു ജഡ്ജ്മെന്റ് കൂടെ ആണല്ലോ. അപ്പോൾ ഈ ഒരു മാൻഡേറ്ററി നോട്ടീസ് ഇഷ്യൂ ചെയ്യേണ്ടത് ഉണ്ടോ എന്നുള്ളതാണ് വീണ്ടും കൺഫ്യൂഷൻ
Mandatory notice, considering the present scenario, it is to be issued. കാരണം അതൊരു പ്രൊവൈസോയില് ഒരു
See,
imposed
it says
clause ആയിട്ട്
that
ചെയ്തതാണ്.
no offense can be taken cognizance of. This is in the negative. And the main provision says regarding cognizance. What is the procedure? Then it is provided as a proviso. It is an exception for subject to.
That is, the proviso is always comes as an exception to the main section.
Subject to. It is subject to the proviso then. Because, and that another thing is that to start with a negative, no offense shall be taken cognizance.
Through that section 210 may take cognizance of any offence. It is clearly said like offence, the word is used. And when I saw the 2021 decision, that's why there is the confusion.
Now there is the scheme is clear that it is added as a proviso. Then we have to first adhere with the proviso. So issuance of the notice as of now, unless it is cleared by the Constitutional Court, it is a specific requirement and should be followed by the courts.
So now the Pradeep Eswada case is not applicable to 138 offences.
That we have limitations to comment on that. That Constitutional courts will clear it. That whether that is required.
138 offences പ്രാക്ടിക്കൽ കോടതിയിൽ ഒരുപാട് വരുന്നതുകൊണ്ടാണ് ഞാൻ ഇങ്ങനെ ചോദിക്കുന്നത്.
That we are also cognizant of that situation. Keeping and sending notice in all cases. See the case of that private complaints with delay, sending notice, again sending notice, and it causes delay. A pragmatic approach suited to the situation has to be evolved. It will be evolved soon. Let us wait for that. So we can wrap up the proceedings today. See you tomorrow with a fresh mind. Till then, bye.